may be seated. I'm going to ask counsel to step up, please, and I'm going to ask the timekeepers not to charge this time against the parties. Would you step up, please?
Good morning, Your Honors.
Good morning.
Good morning, Your Honor.
Are there any preliminary motions?
There are, Your Honors. My name is Todd Van Stolk-Riley, and along with my co-counsel, Ms. Talia Kramer, and Mr. Daniel Goodkin, I represent the people of the State of Midlands in this action. Before these proceedings begin, I have copies of 3 pretrial matters which I would like to tender to the bench. First would be a copy of the stipulations to which both parties have agreed in this matter.
Thank you.
Second would be a copy of the counts against Ms. Tyler Perry, the defendant. And finally, I have a copy of the judgment on cross motions tendered by Judge Butler in regards to this action.
Okay, thank you.
Your Honor, we have seen the documents and agreed to all of them. We also have additional copies of the stipulations and the judgment on cross motions.
All right, thank you.
Thank you.
I'm going to presume the exhibits have been marked. Is that
Yes,
correct?
Your Honor.
Marked for identification.
Yes, sir.
All right, and there are no other matters?
There is one more pretrial
Yes, go
matter,
ahead.
Your Honor. Pursuant to Rule 615 of the Midlands Rules of Court, the prosecution would request that all witnesses be considered constructively sequestered during the course of the proceedings, with the exception of no one.
I will so order. Thank you. All right.
Your Honor, at this time, may defense counsel have permission to make appearances for the record as well?
Say that again.
May I have permission to introduce myself and co-counsel?
Of course.
Your Honor, my name is Samantha Bateman. This is Jamar Walker, who will be giving our opening statement.
Thank you.
Neil Young will be delivering our closing argument.
Thank you.
Together, we represent the defendant in today's action, Mrs. Tyler Perry.
Thank you.
Additionally, Your Honor, one further point of clarification from the defense. Would the court ask that attorneys ask permission before approaching opposing counsel or the witnesses with documents or exhibits?
I will so order.
Yes, Your Honor. With that, we are ready to proceed.
Okay, and I'm presuming the witnesses have been sworn. Is
Yes,
that
Your Honor.
correct? All right, prosecution, you may proceed.
Thank you, Your Honor. Permission to move freely about the well, Your Honor?
Yes, you may. Proceed.
May it please the court. Some things in life are just too important to be gambled with. Chief among these, Your Honors, is the life of those we love. This case is about a woman named Tyler Perry, who learned in the fall of 2004 that her husband was suffering from a deadly and rapidly growing brain tumor. Doctors told the Perrys that without the benefit of a $300,000 operation, Mr. Perry would be dead within 2 short years. With each passing day since that diagnosis, Mr. Perry's chances of survival decreased bit by bit. The evidence in today's case will show that the Perrys attempted by any means to get the money necessary to afford this surgery. The Perrys didn't have $300,000 out of pocket, and they knew that their health insurance did not cover the procedure. And so Tyler Perry began an exhaustive job search. Unfortunately for the Perrys, although Mrs. Perry applied to numerous firms, she received only a single job offer. And she was told that this corporation was likely to rescind that job offer before she could take it, and that the job would not start for another 6 months. 6 months, Your Honors, when Mr. Perry would be dead within 2 years at best. Your Honor, the defendant was desperate, and she made a desperate decision. She chose to take her chances with the law rather than gamble with her husband's life. Having made this decision, the defendant had to choose what gamble she was going to make. She wanted to make sure she had the greatest odds of getting the money she needed for that surgery. And she chose to kidnap and hold ransom Bailey Reynolds, the 13-year-old daughter of her boss and CEO, Ryan Reynolds. Tyler Perry knew the Reynolds well. She knew that they were wealthy. She had even been entrusted by the Reynolds with a key to their home. Only weeks before the incident in question, Your Honor, the evidence will show that Tyler Perry went over to Ryan Reynolds' home, and she announced to him that she was disturbed. She was disturbed for one reason. Ryan Reynolds had denied her her last shred of hope. He had denied her a promotion at their corporation, Fizz Enterprises. We don't need to imagine how the defendant felt when this occurred, because we will hear how she reacted. The evidence will show that Tyler Perry went over to Ryan Reynolds' home. She stormed in the front door. She confronted him, and she yelled at him, "Why didn't you give me this promotion? You know how much I need this money." maybe something terrible needs to happen to your family. And Your Honors, only a week later, something did. On October 22nd of 2004, Bailey Reynolds was kidnapped from her bed. She was drugged with a rare chemical barbiturate known as chlorandramine, and she was held ransom in the Hampton Hotel for $250,000. Your Honor, the evidence will show that Tyler Perry knew she was taking a gamble, and she tried to stack the odds in her favor. The evidence will show today that Tyler Perry invited the Reynolds over to her home on the night in question. She fed them lots of food, and she gave them wine. And then, despite the fact that no one in the party needed more wine, she created an excuse to leave the party. She said she had to purchase an additional bottle of wine. The defendant left her home, leaving the Reynolds there and leaving their children guarded only by a single babysitter. She was gone for over an hour to purchase a single bottle of wine. Now, Your Honor, you will hear from Detective Donnie Walsh in this action, the lead investigator in this case. Detective Walsh will tell you that Bailey Reynolds was recovered from a hotel in Freeport, the very same place Tyler Perry claims she drove that night. He will tell you additionally that this hotel is the same hotel where Tyler Perry was in attendance at a business conference during the entire 3-day period that Bailey Reynolds was kidnapped. Next, you will hear from Mickey Scogan, an employee of that hotel, who will tell you the opportunity that Tyler Perry had in this case. In fact, Your Honors, he will tell you exactly how someone could have snuck a disabled child into that hotel completely unnoticed. Now, Tyler Perry thought that she had made a bet she couldn't lose, but the evidence will show that she made mistakes. She left a trail, and therein her guilt will be proved beyond a reasonable doubt. You will hear today from Bailey Reynolds that she heard Tyler Perry's voice at the Hampton Hotel, but not on the first floor where her business conference was being held, but 2 floors above. You will also hear from Mickey Scogan that Tyler Perry was seen at the Hampton Hotel, but not during normal business hours as she claims, but instead during his graveyard shift from 11 until 7 in the morning. And finally, you'll hear from Detective Donnie Walsh that the same rare barbiturate that was used on Bailey Reynolds was found on Tyler Perry's vehicle. Your Honors, it is our burden to prove beyond a reasonable doubt that Tyler Perry is guilty of the kidnapping of Bailey Reynolds, and we will do so. Thank you.
Thank you, Counsel. Counsel?
Yes, Your Honor. May I proceed?
Yes, you may.
Blinded by the need to blame. No one here denies that something horrible happened to Bailey Reynolds. Someone broke into the Reynolds home, kidnapped their 13-year-old daughter, and held her for ransom. All of us want justice for Bailey Reynolds and her family. But we cannot allow our sympathy to blind us from the facts. Today, you'll learn that in their rush to hold someone accountable, Evanston detectives also rushed to judgment. They were blinded by their need to blame. Your Honors, this is Tyler Perry. For the past 10 years, she's lived and worked right here in Evanston, where she and her husband have raised their 2 young children. For the past 10 years, she's been neighbors and close friends with the Reynolds family. Now, the prosecution has just told you that this is the woman who kidnapped Bailey Reynolds. But they also come before you with a very high burden. They must prove that to you beyond all reasonable doubt. But the facts of today's case will not allow them to meet that burden because Tyler Perry did not commit this crime. As a defense in today's case, we have no burden. Instead, we will ask you to consider 3 questions as you examine the evidence presented today. First, did Tyler Perry have a motive to commit this crime? Second, did Tyler Perry even have time to kidnap Bailey Reynolds on the night of October 22nd? And third, did the police ever fully investigate Peyton Brayla, the Reynolds' own babysitter and the last person the Reynolds saw with their child before she was kidnapped? 3 questions that we'll ask you to consider as you listen to the testimony today. First, motive. To Today you'll hear testimony from Mr. Lawrence Conover. Mr. Conover is the Director of Human Resources at Fitz Enterprises, where he and Mrs. Perry both work. Mr. Conover is responsible for advising Fitz employees about their health care plans. And he will tell you that he confirmed for Mrs. Perry that she had received another job offer from a company with health care benefits that would cover her husband's operation. Second, timeline. As you'll learn, Mrs. Perry was in fact gone from her home for about an hour on the night of the kidnapping to run an errand to the local liquor store. In fact, you'll hear from the liquor store clerk on duty that night, Mr. Francis Gustavo. Mr. Gustavo will tell you that it takes about 20 minutes to drive from Evanston, where Tyler Perry lives, to his liquor store in Freeport. He will also tell you that Mrs. Perry spent nearly 20 minutes inside his store that night. By the end of today's trial, the evidence will show that the only thing Mrs. Perry did that night, the only thing she had time to do, was run an errand to the liquor store and return home. Finally, Peyton Braylow, the Reynolds' own babysitter. Today you'll learn that in their rush to blame Tyler Perry, Evanston detectives overlooked another suspect. Listen carefully to what Evanston police did and did not do when investigating Peyton Braylow. You will learn that Peyton Braylow has a criminal record, and that at the time of the kidnapping, she still had an outstanding criminal fine. You will discover that on the night that Bailey Reynolds went missing, Peyton Braylow was home alone with the Reynolds children. And most importantly, Detective Walsh will tell you that he found Peyton Braylow's fingerprints inside the same hotel room where Bailey Reynolds was confined. And yet, as you'll discover, Evanston police never searched Ms. Braylow's home or her car, and they never brought her down to the station for questioning. Today, you'll also hear from Jordan Nathanson. Mr. Nathanson spent 25 years working for the FBI. He's responsible for training and assessing the work of local detectives. And Mr. Nathanson will tell you that the Evanston police did not follow proper protocol in their investigation of Peyton Braylow. Your Honors, all of us feel sympathy for Bailey Reynolds and the terrible ordeal her family went through. We all want to find and punish the person responsible. The state has decided to blame Tyler Perry. We will ask you today to consider the facts more carefully, blinded by their need to blame. And that is why at the end of today's trial, we will ask that you find the defendant, Tyler Perry, not guilty. Thank you.
Thank you, counsel. Prosecution begin.
Yes, Your Honor. At this time, the prosecution calls Bailey Reynolds to the stand.
You understand you've been sworn to tell the truth. Proceed, counsel.
Could you please state your name for the court?
My name is Bailey Reynolds,
And how old are you, Bailey?
14.
And where are you in school?
I'm in the 8th grade at Churchill Middle School. It's in Evanston.
And where do you live, Bailey?
I live in Evanston with my family.
Do you know a person named Tyler Perry?
Yes.
Do you see Tyler Perry in this courtroom?
Yes, I do.
If you please, could you point to Tyler Perry and describe her for the court?
She's sitting right there, and she's wearing the blue sweater and the headband.
Your Honor, let the record reflect that the witness has identified the defendant.
The record will so show.
Now, Bailey, how do you know Tyler Perry?
Well, she used to be good friends with my mom and dad, or at least I thought they were good friends, except once I overheard something that made me think that they weren't that good of friends.
Where were you at the time?
I was homesick, and I got up to get a glass of ginger ale, and when I did, I heard Mrs. Perry yelling at my dad.
What did you hear Mrs. Perry say to your dad?
She said, "Why didn't you give me this promotion? You know that I need this money." And then she said the strangest thing of all.
To the best of your memory, Bailey, what did Mrs. Perry say to your father?
She said, "Maybe something terrible needs to happen to your family."
Objection, Your Honor. Improper character evidence. May I explain?
Overruled.
Bailey, at what time did this happen?
That was a week before I was kidnapped.
I know this may be difficult for you, but the court needs to hear today about that day. Do you remember what happened on October 22nd of 2004?
Yes. Well, first I went over to my soccer team coach's house for a pasta dinner like we'd always do before a big game.
And where were your parents that evening?
My parents were going over to the Perry's house for dinner.
Who was going to be home while your parents were away?
Well, I was really happy because my parents had gotten Peyton Braylow to babysit, and she's my favorite babysitter. She's always been like a big sister to me.
Bailey, what happened when you got home?
I walked in to the family room. I wanted to say goodnight to Peyton, who was sleeping on the couch. I said goodnight, and I went upstairs to my room, and then I went to bed.
What is the next thing that you remember?
Well, sometime after I fell asleep, I heard the door to my room open, and I saw this shadowy figure. I couldn't tell who it was because the light was coming in from the hallway, so everything was sort of fuzzy. I just figured it was Peyton coming to check up on me like she always does. But then the person grabbed me.
Bailey, can you tell the court what you did?
Well, I tried to fight back. I really did, but before I could, they pressed a cloth over my mouth, and I just blacked out.
What is the next thing that you remember after you woke up?
When I woke up again, my hands were tied, my eyes were covered, and there was something gross in my mouth. And then I was put into a car.
Can you tell the court anything about that car?
Yes. It sounds strange, I know, but the car smelled familiar. I was positive I'd been in it before.
What happened once you were in that car?
Well, we drove for a little while. The car stopped. The kidnapper got out of the car and left me alone. And while I was waiting in the car, I could hear music playing from outside.
What happened next, Bailey?
The kidnapper came back, and we drove away again. And then the car stopped, and that's the last thing I remember for a while.
What's the next thing that you do remember?
When I woke up again, I was in this room, and it was pitch black, and my head hurt so much. My eyes were covered, my mouth was still stuffed, and one of my arms was locked to something metal above my head, so I couldn't move. And I didn't know where I was or what was going to happen to me, and I just cried.
I know this is difficult for you, but can you please tell the court what happened to you while you were in that room?
Well, every now and then, someone would come into the room, pull the gag out of my mouth, shove some food in my mouth, and pour some water down my throat. Then they'd put the gag back in, rush out, and leave me alone again.
How frequently did this happen to you, Bailey?
Well, it felt like it was happening pretty regularly.
How did you ever leave that room?
One day, the door opened and my blindfold was ripped off, and I couldn't see much because my eyes hurt so much from the light, but I did hear for someone to call the police.
Bailey, can you tell the court anything about what you saw while you were kidnapped?
I'm sorry, I wish I could, but you see, the kidnapper kept me blindfolded the whole time, so I couldn't see anything.
Could you tell the court anything that you could hear while you were kidnapped?
Yes. When I was in the room, sometimes I would hear voices, which must have been coming from right outside of the room.
Could you recognize any of those voices, Bailey?
I could only recognize one of them.
Whose voice was that?
It was Mrs. Perry's.
Thank you, Your Honor. No further questions at this time.
Thank you. Any cross?
Yes, Your Honor.
Please.
May I proceed?
You may.
Bailey, I know this is hard, but I need to ask you some questions about what you remember about that night. If you need to take a moment at any time, you let me know, okay?
Okay.
Now, you never saw the face of the person that did this to you.
I couldn't because they kept me blindfolded.
You don't know if the person was tall or short,
No, I couldn't see that, no.
or a man or a woman.
No, I was blindfolded. I'm sorry.
Bailey, on the night you were taken, your parents were having dinner at the Perry's home, right? And that's when Peyton came over to babysit?
Yeah, that's when Peyton came over.
That's Peyton Braylow?
Yes, she's my babysitter.
And then you left your home and went over to your soccer coaches for dinner, right?
That's right.
You got back around 8:30?
No, the dinner ended at 8:30. I didn't get home until around 8:45.
And when you got home, you saw Peyton when you got there, right?
Yeah, Peyton was sleeping in the family room, and I said goodnight to her.
She was asleep?
Yes,
And then you went up to bed?
that's right.
And the last person you saw before you went to bed that night, Bailey, was Peyton Braylow, right?
No, I said goodnight to my little sister Kayla and my little brother Spencer's. I saw them.
But you saw Peyton right before you went to bed when you went upstairs, right, Bailey?
When I was in the family room? Yes.
Thank you, Bailey. No further questions, Your Honor.
Thank you, counsel. Any redirect?
No, Your Honor. We request that the witness step down.
Thank you. You may step down, and thank you. Call your next witness, counsel.
Yes, Your Honor. The prosecution calls Detective Donald Walsh to the stand.
John Walsh.
Donald Walsh, sir.
Officer Walsh, you understand you're under oath.
Absolutely.
Okay. May proceed.
Please state your name for the court, sir.
Sure. My name is Officer Donald Walsh.
And what is your occupation?
I'm a CSI, a crime scene investigator for the Fairfax County Sheriff's Department.
What does your work entail as a CSI?
Well, basically, I collect forensic and testimonial evidence, which I analyze to determine the perpetrator of a crime.
And what general police training have you received?
Let's see. I graduated in 1988 from the Midlands State Police Academy, where I was trained in all standard policing techniques.
And what specialist training have you received to work as a CSI?
Well, I actually trained alongside our boys in the U.S. Marine Corps down in Quantico, Virginia. I received extensive training from the Midlands State Sheriff's Academy, and really the most important training which I get, which is on-the-job training, which I learned from my personal mentor, Officer Ryan Stanfield.
And how many investigations have you personally been involved with, Detective?
God, I'd say hundreds, including about a dozen kidnappings or so.
Thank you. Now moving on.
Excuse me, officer, would you mind removing your gum? Are you
I'm
chewing
sorry,
gum?
I don't have any, no.
Oh, I'm sorry, go ahead.
Thank you, sir. Detective Walsh, how were you involved in the investigation of Bailey Reynolds kidnapping?
I led the entire investigation, led the entire team of investigators from start to finish.
And when did that investigation begin for you?
Let's see, it began on October 22nd, 2004. I received a call over dispatch at 11:07 p.m., which I responded to and arrived at the Reynolds home. There I was met by reporting officer Brian Budzik, in addition to Peyton Braylow, the young woman who had called the police.
And what did you do upon arriving at the house?
Well, first, Deputy Budzik and I examined the exterior of the house, where we found that there were no signs of forced entry. At that point, we proceeded to the interior of the house.
What did you find in the interior?
Well, we found nothing out of place, nothing unusual, until we arrived in the victim's room itself.
And what did you observe when you entered the victim's bedroom?
Well, the room was in complete disarray. There was books strewn on the floor, there was a lamp knocked over, everything was a mess, basically.
And what, if any, physical evidence did you recover at that point, Detective?
Well, at that point, we actually found an 8.5 by 11 sheet of paper at the scene of the crime. Deputy Budzik first picked it up, and then we realized it was physical evidence and took it into evidence.
Your Honor, let the record reflect I am showing opposing counsel, Prosecution 1. Permission to approach the witness, Your Honor.
Yes, you may.
Detective Walsh, please identify that if you can.
This will be the actual note that we found at the scene of the crime.
Thank you, Detective. Your Honor, I offer Prosecution 1 in evidence.
Is there any objection?
From the defense.
It may be received.
Detective Walsh, would you please read for the court what that note says?
Yes, it states in a series of letters cut from newspapers and magazines, I took your kid, $250,000, Houlihan's bathroom, Halloween, 5 to 6 p.m.
Thank you, Detective Walsh. Now, after recovering that note from the bedroom, how did you proceed?
Well, at that point, I began to take fingerprint samples from various places throughout the residence, which the kidnapper may have come in contact with during the commission of the crime. Things like the front and back doorknobs, the banister leading up the stairs, and the desk itself where the note was found.
And what did you do with those samples after recovering them?
Well, I submitted them to Block Laboratories, a state-run forensics lab.
Did you receive a report back at any time from Block Labs?
Indeed, I did.
Let the record reflect I am showing opposing counsel, Prosecution 2. Permission to approach the witness again, Your Honor.
You may.
Detective Walsh, please identify this document if you can.
Sure. This is the Block Laboratories fingerprint analysis report that I received back from them.
Your Honor, pursuant to Judge Butler's ruling, since Detective Walsh collected the evidence this report analyzes, and since this is a Block Labs report, I offer it in evidence.
Is there any objection?
No, Your Honor. Pursuant to Judge Butler's ruling, we have no objection at this time.
May be received.
Detective Walsh, what did you learn based upon that fingerprint report?
Well, you see, the only substance I knew for certain that the kidnapper had actually touched was the ransom note itself. So the first area that I looked at was the ransom note. Then I found that no partial or identified prints were found, with the exception of Brian Budzik's fingerprint. From this, I was able to conclude that the kidnapper was not leaving fingerprints that night, most likely due to the fact that they were wearing gloves.
See, Detective Walsh. Now, what, if any, forensic evidence did you recover from the crime scene?
I collected the bedding on Bailey Reynolds' bed in addition to the pillowcase, also found on the victim's bed.
What did you do with those items?
Again, submitted them to the state-run forensics lab.
Did you receive a report back from Block Labs?
Indeed, I did.
Let the record reflect I am showing opposing counsel, Prosecution 3, Your Honor. Permission to approach.
You may.
Detective Walsh, please identify that if you can.
Yeah, this is a report I received back from them.
I offer Prosecution 3 in evidence pursuant
Is there any
to Judge
objection?
Butler's ruling.
Pursuant to that ruling, no objection.
May be received.
What did you learn from that report, Detective?
I learned that the barbiturate chloroandramine was found on the pillowcase taken from Bailey Reynolds' bed.
Are you familiar with the drug chloroandramine?
Indeed I am. I was trained in its properties and general use in the commission of crime while attending the Sheriff's Academy.
In that case, could you please describe for the court what exactly chloroandramine is?
Well, chloroandramine, like I said, is a barbiturate. It can be applied to a rag, applied to a victim's mouth, and render them unconscious for a period of 1 to 2 hours.
Thank you, Detective Walsh. Did this complete your investigation of the original crime scene?
No. At this point, I began taking testimonial evidence from the parents of the victim as well as Tyler Perry, the woman whose house they were at that night.
What, if anything, of relevance did you learn from these interviews?
Well, very early on, due to the testimony given to me by Tyler Perry, she emerged as a likely suspect.
And what did you learn from Tyler Perry that led you to consider her as a suspect?
I learned that her husband, KC, was suffering from a very extensive and rapid-growing brain tumor, which necessitated a very expensive operation to fix. Furthermore, I learned that the parent of the victim, Ryan Reynolds, was her boss and had recently denied her a promotion.
Now, where did the defendant claim to have been on the night of the kidnapping?
Well, for the majority of the night, she claimed to have been at her home, and this fact was substantiated by the parents of the victim. However, she left that home for a period of just over an hour, a time during which her actions could not be accounted for.
And where did the defendant claim to have gone during that time?
Well, she claimed to go to Freeport Fine Liquors.
Now, Detective Walsh, where was Bailey Reynolds ultimately found?
She was found in the Hampton Hotel, also in Freeport.
See, Detective. And at what time was Bailey Reynolds found there?
She was found the following Monday, about 3 days later.
Now, in between the time Bailey Reynolds was taken from her room and the time she was found in the Hampton Hotel, where did the defendant claim to have been?
Well, the defendant, Tyler Perry, admitted under interrogation that she had been at the hotel that entire weekend. A very important fact for my investigation since Bailey Reynolds was regularly fed during this time period.
See, Detective Walsh. Now, did you come to examine any other scenes in the course of your investigation?
Indeed, I did. I obtained a search warrant for Tyler Perry's home and vehicle.
Did you search those locations?
Yes, I did.
And what did you find during those searches?
Well, I found nothing of significance in the house. I found several pieces of forensic evidence throughout the defendant's automobile.
What evidence did you find?
Well, I found in the trunk 3 unopened bottles of wine. I also found 6 strands of hair in the back seat of the vehicle, and I took chemical swabs of the steering wheel and the front and back door handles on the driver's side of the vehicle.
And what did you do with the hair samples and the chemical swabs?
I submitted both of these to Block Laboratories for further analysis.
Did you receive a report back from Block?
Indeed, I did.
Let the record reflect I am showing opposing counsel Prosecution 4. Permission to approach the witness, Your Honor.
May.
Detective Walsh, please identify that if you can.
Sure. This is the Block Lab's DNA analysis on the hair and the chemical analysis on the 3 residue swabs which I took.
Your Honor, I offer Prosecution 4 in evidence.
Is there any objection?
No, Your Honor. Pursuant to the judgment on cross motions, we have no objection at this time. We just ask that a pretrial objection be noted on the record and preserved for appeal.
It may be received.
Detective Walsh, what did you learn from that report about the hair that you found in the defendant's car?
Well, Block Laboratories found that that hair was a complete DNA match to that of Bailey Reynolds, the victim.
And what did you learn about the residue swabs taken from the defendant's car?
All 3 residue swabs I took from Tyler Perry's vehicle revealed trace elements of the barbiturate chloroandramine, the same one used in the commission of the crime.
Detective Walsh, did this complete your investigation?
Well, for that time, it did, yes.
And what did you do at that point?
At this point, I arrested Tyler Perry for the kidnapping of Bailey Reynolds.
Thank you, Detective Walsh. Nothing further at this time, Your Honor.
Thank you, counsel. Any cross?
Yes, Your Honor.
Your Honor, permission to approach and tender evidence to the bench.
Yes, you may. Now, what you're showing us are copies of what you've already given us. Is that correct?
Your Honor, these are
Accept.
Prosecution 1 through 4, which have been entered through Detective Walsh during the direct examination.
All right, thank you. Excuse me.
Yes, Your Honor.
May proceed.
Now, before I begin, may I have permission to approach the bench to retrieve previously admitted evidence, specifically Prosecution 4?
Yes, you do. Number 4.
Number 4 is the
That's
one
the
on top.
DNA.
Yes, Your Honor.
Here you are.
Thank you very much. Detective Walsh, I'd like to start by talking about the physical evidence in this case that you claim points to Tyler Perry.
Absolutely, Ms. Bateman.
Your Honor, may I approach the witness?
Yes, you may.
Handing Detective Walsh what has been entered into evidence as States 4. Detective Walsh, you recognize that document as the document from Block Laboratories regarding Mrs. Perry's automobile, correct?
Right, this is the analysis of the 6 strands of hair I found in the back seat and the 3 chemical swabs I took from the 3 places throughout the Perry vehicle.
Directing your attention to the top portion of this document.
Yes.
The DNA analysis report on the hairs. Now, this document can't tell you when those hairs got into Mrs. Perry's car, can it?
The document itself does not. It does state all the hair that I found in the vehicle, which was only these 6 strands. From that, I am able to extrapolate that they were recently placed there, but I'm unable to identify the exact time they were left.
The document does not tell you when those 6 hairs got there.
No, I give it to Block, and then they just do an analysis of it. I tell them when it was found there.
Now, this document also doesn't tell you how the 6 hairs got into Mrs. Perry's car.
No, a document doesn't tell me anything like that.
Well, the second half of this document, the chemical analysis report on the swabs taken from Mrs. Perry's car, it can't tell you when the chemical chlorandramine got into Mrs. Perry's automobile.
Again, no, I use my CSI training to determine that. It doesn't come from the document. It comes from my years of experience.
I'd move to strike the witness's response as non-responsive to the question. I'm simply asking him whether the document tells him that information.
Those latter remarks will be stricken.
Now, Detective Walsh, this document specifically does not tell you how the chemical chlorandramine got into Mrs. Perry's car either.
No, in regards to chlorandramine, it only shows that it was, all 3 swabs were those of the barbiturate chlorandramine. That's all it states.
Does not tell you how the chlorandramine got there.
No, that's right.
I'd like to talk then about the collection of physical evidence in this case. You've been trained in proper evidence collection techniques, correct?
Absolutely. As a CSI, that's what I'm trained in.
You testified that you have specialized training from the Marines in Quantico.
That's correct.
However, when you were collecting physical evidence in this case, another officer was present with you named Deputy Budzik, correct?
Right, in the initial part of the investigation when we patrolled the house.
When you patrolled the house, you also searched Bailey Reynolds' bedroom.
Yes, that is correct. Yes.
And when you searched her bedroom, you observed Deputy Budzik handling the ransom note in that room without wearing his gloves. Isn't that true?
Right. Deputy Budzik, patrolling officer, initially picked it up. I immediately had him place it back down and put on a pair of gloves. I always keep an extra pair.
Well, he didn't just pick up the ransom note. He picked it up without wearing his gloves. Isn't that true?
Yeah, that's absolutely correct. Unfortunate mistake, but thankfully it didn't contaminate the evidence.
Move to strike the latter portion of the witness's
It will be
response.
stricken.
Detective Walsh, you're aware that handling evidence without gloves, well, that's a violation of proper police protocol, isn't it?
Absolutely, and Deputy Budzik was penalized for that.
I'd like to turn your attention now to the other evidence that you found inside the Reynolds residence. Now, as you mentioned earlier, you searched for fingerprints all throughout that home.
Yes, that is correct.
You never found Mrs. Perry's fingerprints anywhere inside Bailey Reynolds' bedroom.
No, like I said, I did not find her prints on the bedroom. I also found no prints on the ransom note.
You also, however, found the prints of an individual named Peyton Braylow throughout the house. Isn't that right?
Yeah, Peyton Braylow was actually there when I arrived.
Peyton Braylow was the babysitter at the residence that evening.
Yeah, she showed us the crime scene. She was the one that called the cops.
Now, the other scene that you mentioned, searching and dusting for fingerprints, was the Hampton Hotel. Is that correct?
Yes, that is correct. I wanted to make sure in the case that the kidnapper took off the gloves, that we would be ready. Sometimes they make a slip up.
For fingerprints all throughout that hotel room. Isn't that true?
Yes, that's correct.
And you received a report from Block Laboratories from the fingerprints that you found.
Yes, that's correct.
Honor, may I have permission to approach opposing counsel this time? Handing opposing counsel a copy of what has been marked for purposes of identification as Defense A. May I approach the witness?
Yes, you may.
Handing the witness a copy of that same document. Detective Walsh, you recognize that document as the fingerprint report on the fingerprints found in room 312 at the Hampton Hotel.
Yes, that's what it is.
It's a report from Block Laboratories?
Yes, that's correct.
It's a fair and accurate copy of that report.
Yes.
At this time, we offer this into evidence as Defense A. This is also subject to Judge Butler's ruling on cross motions.
Is there any objection?
Pursuant to Judge Butler's ruling, no objection, Your Honor.
Thank you. It may be received.
And Detective Walsh, that document indicated to you that the fingerprints of an individual named Peyton Braylow were also found in room 312 of the Hampton Hotel.
Yeah, they were found all over the room. She was a hotel maid there.
Room 312 of the Hampton Hotel, that's where Bailey Reynolds was confined.
Yes, that's correct.
And at this time, may I have permission to approach the witness and the bench to tender that evidence?
Yes, you may.
Yes, thank you. There you are, Your Honor.
Thank you.
You found the fingerprints of Peyton Braylow. However, you never found the fingerprints of Mrs. Perry anywhere in that hotel room. Isn't that true?
That is correct. The kidnapper left no traces of fingerprints.
Well, you did find that Bailey Reynolds was handcuffed to a pipe in the bathroom when you arrived.
Yes, that's correct.
And you searched Mrs. Perry's home and vehicle thoroughly in your investigation.
Absolutely.
You never found a handcuff key anywhere in her possession.
No, unfortunately, with a major media case like this, that did not happen.
Your Honor, I'd move to strike the latter portion of the witness's response.
It may be stricken.
Your Honor, please instruct the witness to only answer yes or no to questions that only require yes or no.
I'd ask
answer.
that you do so. Thank you.
Detective Walsh, you never found a handcuff key anywhere in Mrs. Perry's possession.
No, we never found a handcuff key.
And room 312 in the Hampton Hotel, it has a key lock on it, correct?
Yes, that is correct.
You never found a Hampton Hotel key anywhere in Mrs. Perry's possession either.
No, no Hampton Hotel key was found during the course of the investigation.
However, you are aware that Peyton Braylow works at the Hampton Hotel, isn't that right?
That's right. She cleans on the 3rd floor there.
In fact, you were made aware in the course of your investigation that she has access to a master key that will open all guest rooms.
Objection, Your Honor. Question calls for testimony based on hearsay.
No, that's overruled. If you know the answer, you can answer it.
Detective Walsh, in the course of your investigation, you were made aware that Peyton Braylow has access to a master key that opens all guest rooms.
Yeah, Peyton Braylow readily came forward with that first time I interviewed you.
That master key would open room 312.
Yes, it would. That's where she cleaned.
Now, you also, as part of your investigation, conducted a criminal background check on Peyton Braylow. Isn't that right?
Yeah, as a formality, we do that with most of the people we interview.
And at this time, may I have permission to approach opposing counsel?
Yes, you may.
Approaching opposing counsel and showing him what has been marked for identification purposes as Defense B. May I approach the witness?
Yes, you may.
Now showing Detective Walsh a copy of that same document. Detective, you recognize that as the criminal records report on Peyton Braylow.
Well, actually, there seems to be parts of it that are blacked out, but it looks like initially it may have been.
Well, Detective Walsh, you recognize that as a portion of it with the upper portion redacted, correct?
Yeah, there are large blocks of it that are marked over with marker.
And the second half of it, you recognize as a fair and accurate copy of the second half of the report you received.
Yeah, the second half appears to be untampered with.
At this time, we offer this into evidence as Defense B. Portions of this have been redacted.
Is there any objection?
Yes, Your Honor. Objection to relevance. This document, if I may make an offer of proof, contains information about a charge for the possession with intent to distribute methamphetamines. That drug is not at issue, has not been mentioned in the proceedings today, and I would contend, and I would offer, will not be. Thus, this charge has no relevance.
May I see the document, please? Now, what do you believe is the relevance?
Yes, Your Honor. We believe this is relevant to the issue of the identity of the kidnapper for two reasons. Now, first, this indicates that Peyton Braylow had a criminal fine imposed upon her before the kidnapping. Now, that's relevant to show that Ms. Braylow, another potential suspect in this case, might have had motive to commit this kidnapping. And secondly, this also shows that Ms. Braylow had prior knowledge of drugs like chlorandramine, drugs that she might even be able to manufacture, as she was caught with possession with intent to distribute methamphetamines and also drug ingredients. Now, this would establish prior knowledge of how to obtain or possibly manufacture the drug used in this case.
How do you respond, counsel?
Yes, Your Honor. No foundation whatsoever has been laid that methamphetamines have any relation to chlorandramine. Also, Peyton Braylow was only charged with possession of those drugs. The plea was Peyton Braylow actually pled guilty to the lesser offense of possession of drug paraphernalia, including ingredients. No foundation has been laid that any of these drug paraphernalia in any way relate to chloroangemine. Until such time as that foundation is laid, those charges are irrelevant, and their admission would be more prejudicial than probative.
Your Honor,
What is your response?
Yes, Your Honor. With response to the more prejudicial than probative objection, this clearly is probative to establish that another suspect in this case might have had a potential monetary motive and also knowledge or access to drugs. Now, secondly, we'd be offering this for its effect upon Detective Walsh, because if Detective Walsh was aware that another suspect in this case had a criminal record and failed to interrogate her or search her home or vehicle, as subsequent questioning will establish, that goes directly to his credibility and calls into doubt any of the findings he's offered us on direct.
Counsel?
Yes, Your Honor. Your Honor, the issue of Peyton Braylow's character generally for the possession of drugs of some sort is simply not relevant to the proceedings and would be improper character evidence pursuant to Rule 609. The evidence that Peyton Braylow had to pay a fine would be relevant to the issue of motive. However, the question of the information about some drug paraphernalia which she possessed is simply not relevant.
I'm going to allow it in, and we will give it the appropriate weight. Thank you.
Yes, Your Honor.
Detective Walsh, from that document, you were made aware that Peyton Braylow had actually pled guilty to possession of paraphernalia and ingredients to manufacture methamphetamine, correct?
Could I actually see that document? I learned from that document that she pled guilty to possession of drug paraphernalia, but not necessarily that which would make methamphetamines, no.
Well, she was ordered to pay a criminal fine as a result of her conviction.
It's right, $50,000 over the course of 5 years.
And on the night of October 22nd, 2004, according to that document, she still had $20,000 left to pay.
Right, this shows that she paid off $30,000 of this, $10,000 each year.
Permission to approach the witness and the bench attorney
Yes, you
for
may.
the evidence. Thank you, Detective. Detective, as you told us earlier, Peyton Braylow was actually at the crime scene at the Reynolds residence when you arrived that night. Isn't that true?
Yes, that's correct. She had called the police.
She was alone with the 3 young children.
Right, she was with 2 children at that point.
And she also told you that she had been asleep during the time that this kidnapping took place.
Yes, that is correct.
However, you searched Bailey Reynolds' bedroom.
Her bedroom? Yes, I did.
And as you noted, there were signs of a struggle in that room.
Yes,
Some bed sheets had been pulled off of the bed.
that's correct.
Lamps had been knocked off onto the floor.
The lamp had been knocked on top of the bed sheet, yes.
It had been knocked onto the floor.
Well, yes, the bed sheets were on the floor and the lamp had been knocked down on top of that.
The lamp had been knocked onto the floor, Detective Walsh.
Right, that's right.
Some books had also been knocked off of Bailey's desk and onto the floor.
Right on top of the bed sheets.
Well, Detective, what I'd like to do now is compare the times that Mrs. Perry and Peyton Braylow would have had to commit this kidnapping. Now, as you told us earlier...
Your Honor, to the form of the question.
Would you repeat your question, please?
Yes, Your Honor. I was simply clarifying for the witness that I'll be asking him to compare the times that Mrs. Perry might have had to commit the kidnapping with the time that Peyton Braylow might have had on the
There's
night.
cross-examination. She may do so. Go ahead.
Yes, Your Honor.
Detective, as you told us, you were made aware that Mrs. Perry was gone from her home for a period of about an hour on the night of the kidnapping.
Yes, that's correct.
However, you are aware that Peyton Braylow was alone with the Reynolds children from the time that the Reynolds parents left until the time that she placed the 911 call.
Yes, well, except for when the kidnapper entered the house.
And when Peyton Braylow went to sleep on the couch, supposedly, you don't have anyone else who can verify her whereabouts for that time period after Bailey Reynolds went to bed.
Right, Bailey Reynolds verified that she was asleep on the couch when she arrived home, and then went back to sleep after she said hello to her upon her arrival.
Well, Bailey arrived home at around 8:45 or 9 o'clock.
That's correct.
No one else can account for Miss Braylow's whereabouts for the 2 hours between that time period and the 911 call at 11:07 p.m.
No, unfortunately, there was no one else at the house to prevent the kidnapping.
However, Detective Walsh, despite all of this information, you never brought Peyton Braylow down to the station to question her as a suspect in this case.
Well, I questioned her twice, not at the station, no.
So the answer to my question is no, you never brought her down to the station to interrogate her as a suspect.
No, not at the station. There was no reason, and during my previous 2 interviews, it was more than helpful.
Well, you never searched Miss Braylow's home.
Right, that's correct.
You never searched her car.
Her car?
You never searched her car if she had one.
Oh, she didn't have one. I didn't search her bike.
And you never tested her hands or the clothing she was wearing on the night in question for residue for the chemical chlorandramine, did you?
No, there was no need to do that.
Detective Walsh, my question was you never tested, did you?
No.
Because you never tested, you cannot tell us if Peyton Braylow had residue from the chemical chlorandramine on her hands or on her clothing on the night of October 22nd, 2004.
I cannot tell you that she ever had any access to chlorandramine on that night or at any other time. No.
No further questions, Your Honor.
Thank you. Redirect?
Yes, Your Honor. Permission to approach the bench and retrieve evidence?
Yes, you may.
And evidence to the witness, Your Honor.
Wait, excuse me. That's right.
Detective Walsh, what year was that conviction for Peyton Braylow?
Peyton Braylow, let's see, I believe it was January in 2002.
And did you find any evidence that she had access at any point to chlorandramine based upon that conviction?
No, not at all.
And were you able to explain at all how Peyton Braylow's fingerprints may have appeared in room 312 of the Hampton Hotel?
Yes, they were found all over the hotel. They were the only ones we were able to identify because they were up in like the hard-to-reach places, like over the lamps where the cleaning ladies work.
Detective Walsh, why did you not believe it was necessary to search Peyton Braylow's house?
There was absolutely no reason to consider her a suspect. Nothing about her behavior was suspicious, and there was nothing unaccounted for of her actions that night.
Did your investigation of Peyton Braylow, was it in accordance with standard CSI procedure, Detective?
Absolutely.
Thank you, Detective Walsh. Nothing further, Your Honor.
Thank you, counsel. You may step down.
Thank you, Your Honor. Would you like to copy this?
Okay, we'll take that. Do you have any further witnesses?
Yes, Your Honor. The prosecution calls Mickey Scogan to the stand.
Okay.
And permission to set the court for a demonstrative before proceeding, Your Honor?
Yes. Now, how do you spell your full name, please?
That would be M-I-C-K-Y. S-K-O-G-A.
Thank you. Do you have some? Thank you.
May I proceed?
Yes, you may.
Would you please state your name and age for the court?
Certainly. My name is Mickey Scogan, and I am 26 years old.
Are you employed, Mr. Scogan?
I am, yes. I'm currently working as a bell desk clerk at the Hampton Hotel, which is in Freeport. I work the weekend night shift, which would be from Friday to Monday, from 11 p.m. to 7 a.m.
What are your duties as a front bell desk clerk at the Hampton Hotel?
Well, as a bell desk clerk, I am primarily responsible for customer relations at the front desk of the hotel, which involves an extensive number of things. I'm in charge of making room reservations, responding to any customer requests, as well as responding to any problems at the hotel, say when the neighborhood children attempt to use our hotel lawn chairs as pool toys.
Mr. Scogan, where is your hotel located?
Well, our hotel is located in Freeport.
Are you familiar with the area surrounding your hotel?
I've been working at the hotel for several years now. I would say, yes, I am quite familiar with that area.
Permission to use the demonstrative, Your Honor.
Your Honor, may I request permission to move about the courtroom so as to better be able to see the demonstrative?
Yes, you may.
Mr. Scogan, do you recognize the area depicted on this map?
Yes, that is the area directly around the Hampton Hotel. You can see the hotel is that rectangle at the bottom there.
Based on your experience with the area, does this map appear to be a fair and accurate depiction of that area?
This is, as familiar as I am with the area, yes, this appears accurate.
Mr. Mr. Scogan, are you acquainted with an establishment called Freeport's Fine Liquors?
I should admit, yes, I have visited that store on a number of occasions in search of a fine bottle of bourbon, yes.
Mr. Scogan, where is Freeport's Fine Liquors relative to your hotel?
Well, I believe it is labeled on this map as well. It's that building in between the pet store and the hardware store. It's labeled Freeport Fine Liquors, and it's actually connected to the Hampton Hotel by a road which passes under the highway.
Thank you, Mr. Scogan.
Excuse me, Counsel, has that diagram been marked for identification?
Your Honor, this diagram is only being used for demonstrative purposes, and
All right.
all exhibits are
You
assigned.
may mark it if you'd like for identification, but that's fine.
Yes, sir.
Thank you.
Mr. Scogan, directing your attention to the weekend of October 22nd to 24th, 2004, were you working at the Hampton Hotel that weekend?
I was, yes, as I work most weekends.
Was there anything out of the ordinary taking place at your hotel that weekend?
Well, I do remember the hotel was particularly busy that weekend. We had a company by the name of Fitz Enterprises, which had rented out our 2 large first-floor conference rooms for some event they were holding, and as such, yes, it was a rather crowded event.
Which shifts were you working that weekend?
The same shifts which I always do, the night shift, Friday, Saturday, Sunday, and Monday. And I should also mention that I worked the Monday afternoon shift. I covered for Sammy when he called in with back trouble.
Directing your attention to that Monday afternoon shift.
Yes.
How did work begin for you that day?
Well, it was a completely normal day. I made several towel deliveries. I made several room reservations as well. I do recall at one point I had to stop a young woman who was attempting to sneak out of the hotel with several hotel towels and a small lamp hidden underneath her shirt. Really, it was basically business as I'm used to it until around 2 p.m.
What happened at 2 p.m.?
It was at 2 p.m. that a young woman, a guest at our hotel, came down to the front desk complaining that she was hearing some sort of banging noise like a broken pipe coming from the room next to hers. Now, I'm no plumber, but naturally I responded to this guest's request that I go up and check on the noise.
What did you find when you went upstairs?
Well, I knocked on the door of the room, and when I received no answer, I did enter. And when I did enter, the room was completely dark. I saw nothing of interest in the room itself, and I immediately proceeded to the bathroom of the room, where I got the shock of my life.
What did you see upon entering the bathroom, Mr. Scogan?
Well, I saw a little girl. The room was completely dark. The lights were off, but there was a little girl huddled up on the floor of the bathroom, and she was blindfolded and gagged, and she had been chained to a pipe underneath the sink. That was the sound that the guest had been hearing.
What did you do?
Well, immediately I shouted for someone to call the police, and while the police were being called, I attempted to comfort the girl. Of course, I could remove the blindfold and the gag, but I couldn't remove the handcuffs myself.
Did the police arrive?
Yes, thankfully they did, and they did have a key for the handcuffs, yes.
What happened after the police arrived?
They freed the girl, of course, and at that point they led her away, and they asked me several questions about how I had found her, after which I got back to work.
Now, Mr. Scogan, I'd like to discuss the layout of your hotel. When you work at the front bell desk, where exactly are you located?
Well, the bell desk is located in the front lobby of the hotel, as I'm sure it is in many hotels.
How many entrances are there to your hotel?
Well, the Hampton actually only has one entrance. It was built many years ago before fire regulations are what they are today. So I'm afraid, even though the fire marshal isn't happy about it, guests and hotel employees all must use one entrance.
Where is the front bell desk located relative to that front entrance?
Right when you come in the entrance, you see the bell desk directly ahead of you. The idea being the guests know where to come when they enter the hotel.
Mr. Scogan, when you're on duty as the front bell desk clerk, are you actually located at that front desk the entire time that you are working?
Well, it does vary. As a bell desk clerk, I have a number of duties. As I mentioned earlier, I often have to respond to guest complaints or bring things to guest rooms, or, as was that one case I described, chase down women who have lamp-shaped bellies.
So in your experience, are there times that the front desk at the Hampton Hotel is unguarded?
That is what I'm saying. We even have a situation in that eventuality. We have a small sign that we put up that says, "Be back soon," and a bell that the guest can ring if there's no one at the desk when they get there.
Mr. Scogan, are you acquainted with a woman named Tyler Perry?
Yes, I am. I know her.
Do you see her present in this courtroom today?
I do. Yes.
Would you please point her out to the court based on what she's wearing and where she's sitting?
She's the young woman dressed in blue right over there.
Your Honor, let the record reflect that the witness has identified the defendant as Tyler Perry.
The record will so reflect.
Mr. Scogan, did you see Tyler Perry at all over the weekend of October 22nd to 24th, 2004?
I did, yes. I did see her that weekend.
When did you see her that weekend?
I saw her while I was working at my normal shift at the Hampton Hotel.
Would you please remind the court the hours of your normal shift at the hotel?
Yes, as I mentioned earlier, that would be the night shift from 11 p.m. to 7 a.m. in the morning.
Thank you, Mr. Scogan. No further questions, Your Honor.
Thank you. Any cross?
Yes, Your Honor.
You may.
May I proceed, Your Honor?
Yes, you may.
Good afternoon, Mr. Scogan.
Good afternoon.
You just said on direct testimony that over the weekend of October 22nd, you saw Tyler Perry at the Hampton Hotel, right?
I did see her, yes.
I'd like to talk to you about another individual you saw at the Hampton Hotel during that weekend. You know someone named Peyton Braylow, right?
Yes, she is a pleasant young woman. She works at the hotel with me, yes.
Miss Braylow works as a housekeeper at the Hampton Hotel.
That's correct, yes.
Now, as a housekeeper, Miss Braylow cleans guest rooms, right?
That would be the duty of the housekeeper, yes. She is one of many.
And in order to clean guest rooms, Miss Braylow would have to have access to a master key that can open those rooms, right?
Yes, as I imagine is the case in most hotels, when a housekeeper needs to enter a room to clean it, she does need a way to enter the room. And yes, all housekeepers who are on shift do have keys with which they may enter the rooms they clean.
Now, those master keys, they'll open any room in the Hampton Hotel, any guest room, right?
That's correct, yes. Any room that must be cleaned can be opened.
Including the door to room 312?
Yes, that could be opened as it was a guest room.
So Ms. Braylow had access to a key that could open the door to room 312.
While she was on shift and had to clean that room, yes, that's correct.
In your experience, Mr. Scogan, Peyton Braylow doesn't work weekends. Isn't that right?
Well, typically, she does not, no.
Prior to the weekend of October 22nd, 2004, you'd never observed Ms. Braylow working a weekend shift. Isn't that right?
Well, no, I never had, but I only worked the night shift. It is, of course, possible that she was there during the day. I'm not entirely sure.
But on the weekend of October 22nd, you saw Peyton Braylow at the Hampton Hotel, right?
Yes, I did see her briefly in passing.
A weekend you know for sure Peyton Braylow was not scheduled to work.
I can't be sure she wasn't covering for someone, but I know she typically does not work during that time.
So you know that the schedule that was posted, according to that schedule, Ms. Braylow wasn't supposed to be in that day.
As far as I know, she wasn't. Again, there may have been a scheduling change, as was the case with Sammy when I covered for him. He just called me to ask if I could cover for him.
Well, you saw Ms. Braylow, Mr. Scogan, at 11 o'clock on Sunday night, right?
Yes, just as I was beginning my 11 p.m. shift.
When you saw Ms. Braylow, you were downstairs in the lobby refilling coffee filters.
Coffee canisters, yes. We use the finest premium blend at the Hampton, and I was by the bell desk refilling our coffee, yes.
You were standing by the bell desk.
I was.
And you saw Ms. Braylow rushing through the lobby, right?
That's correct. She was walking rather quickly back from the back of the hotel out the front entrance.
You describe her as practically running towards the door.
Yes, she was walking quite quickly. She seemed to be in a hurry.
Mr. Scogan, you called out to Ms. Braylow, right?
Well, from where I was working by the bell desk, I did notice her, and I attempted to say hello.
You shouted out.
Yes, I shouted, "Hello, Peyton," or something to that effect, yes.
But Ms. Braylow didn't stop, did she?
No, I suppose she didn't hear me, and when I noticed that, I just went back to refilling the coffee canisters.
So despite the fact that you shouted for her to stop, Peyton Braylow kept running towards the door.
That's correct. She just kept walking. I just suppose she didn't hear me.
Well, Mr. Scogan, you testified earlier that the reason you knew something was wrong in room 312 was because you received a complaint about a clanging noise coming from room 312.
Yes, a guest originally believed that it was just a broken pipe.
But as you found out when you went into that room, it was actually the noise that Bailey Reynolds made, clanging against the pipe she was chained to.
It was terrible to see, but yes, it was the handcuffs clanging against the pipe underneath the sink.
Mr. Scogan, isn't it true that the first time you ever received a complaint about a clanging noise coming from room 312 was immediately after Peyton Braylow rushed out the front door of the hotel that Sunday night?
The first time that that guest did complain was the night before, yes, at the 11 o'clock shift.
Immediately after Peyton Braylow was seen rushing out the door?
Just after she did come down at that time, yes.
No further questions, Your Honor.
Okay, thank you. Redirect.
Yes, Your Honor. May I proceed?
See.
Mr. Scogan, aside from that one time briefly Sunday night, did you see Peyton Braylow at all again that weekend at the hotel?
I did not see her the rest of the weekend when I was working, no.
Thank you. No further questions.
Thank you. You may step down.
Thank you, sir.
Thank you. Does the prosecution have any other witnesses?
No, Your Honor. At this time, the prosecution rests.
All right, thank you. Defense?
Yes, Your Honor. At this time, the defense calls Mr. Lawrence Conover to the stand. Your Honor, before I begin, may I have permission to take down the easel?
Yes, you may. Yes, just a moment. Mr. Witness, you understand that you're under oath?
Certainly.
And will you please spell your full name?
Oh, that's Lawrence Conover. L-A-W.
L-A-W.
R-E-N-C-E.
Mm-hmm.
And my last name's Conover. That's K-O-N-A-N-O-V-A.
Okay, thank you. Counsel?
Mr. Conover, just to be clear, could you please state your name and spell your last for the record?
Absolutely. That's Lawrence Conover. K-O-N-A-N-O-V-A.
Mr. Conover, where do you live?
I live in Hillsborough. It's just outside of Evanston.
Could you please describe your professional background for the court?
My background is in human resources. It's the study of how to organize and allocate human assets in the workplace. I earned my PhD from Northwestern with a specialization in occupational psychology. Very exciting stuff. And I've been putting those techniques to work for Fitz Enterprises for the last 10 years.
What exactly do you do at Fitz Enterprises?
Well, currently, I'm Director of Human Resources.
What sorts of duties and responsibilities do you have as Human Resources Director?
Well, my office oversees all personnel activities at Fitz, everything from hiring and staff relations to compensation and health care benefits.
You mentioned health care benefits. What kind of duties do you have with regards to Fitz Enterprises' health care plan?
Well, I'm essentially the mediator between Fitz's health care provider and all the workers at Fitz. If any of the employees have questions about their health care plan, well, they come knocking on my door.
What kind of questions are you responsible for answering?
Oh, anything, really. Premiums, deductibles, whether certain operations are covered under an employee's plan. I've got to know it all.
Mr. Conover, turning your attention now, do you know an individual named Tyler Perry?
Oh, absolutely. Tyler's a coworker of mine at Fitz. Actually, we're close family friends.
How often would you say you interact with Mrs. Perry at work?
I'll see Tyler around the office about every day, and we'll do lunch around every week or so. I'll tell Tyler how things are going at the Conover household, and well, she'll tell me about the kids and how KC is doing.
Mr. Conover, earlier today we found out that in October of 2004, the defendant's husband needed an expensive operation. Were you aware of that?
I was, yes.
Well, as the individual at Fitz Enterprises who advises Fitz employees about their health care plans, had you ever given any advice to Mrs. Perry about how she could pay for her husband's operation?
I had to tell Tyler that, unfortunately, Fitz's health care plan wasn't going to cover her husband's operation. I also told Tyler that, well, under her circumstances, one of her best options might be to consider employment with another publishing firm, one that had a better health care plan.
Did you ever speak with Mrs. Perry after you gave her that advice to seek employment in another firm?
I did, later that week.
Could you describe that conversation to the court?
Well, Tyler burst into my office. She was ecstatic. Well, she had a letter in one hand and an envelope in the other. She told me she was going to take a job with Hawley Publishing, another local firm.
Was that the end of the conversation?
Oh, no. Just before she left, she asked whether or not Hawley would cover her husband's operation.
Well, did you ever report back to Mrs. Perry about whether or not Hawley Publishing's health care plan would pay for her husband's surgery?
Objection, Your Honor. Calls for hearsay.
I'm going to allow, well, what is the basis for your objection?
Yes, Your Honor. In order for this witness to have been able to confirm for Mrs. Perry that Holly's insurance carrier would or would not cover her surgery, he would have had to speak to someone at that insurance carrier. Therefore, that information would be based on an out-of-court statement made by someone other than this witness.
How you respond, counsel?
Yes, Your Honor. We're not attempting to prove as a matter of truth that Holly Publishing would cover Mrs. Perry's husband's surgery, simply that she had reason to believe so. Now, Mr. Cononova told this information to Mrs. Perry. We're offering it for its effect upon her state of mind, as it would mitigate a claim of motive in this case.
I'm going to overrule your objection. Thank you, counsel.
Mr. Cononova, did you ever report back to Mrs. Perry about whether or not Holly Publishing would cover her husband's operation?
I did later that afternoon.
Can you tell us what you told Mrs. Perry that afternoon?
I told Tyler everything I know about Holly Publishing. On the one hand, Holly, like many publishing firms, has been known to rescind job offers in the past. But unlike Fitz Enterprises, Holly has a stellar healthcare plan, one that would cover KC's operation.
Do you remember the exact date you told Mrs. Perry that her husband's operation would be covered?
It was the 20th of October in 2004.
I need to shift your attention now, Mr. Cononova, to that weekend, the weekend of October 22nd. Do you recall what you were doing that weekend?
Well, of course. I was at the annual Fitz Enterprises conference. It lasted Friday through Sunday.
Which days did you attend the conference?
Oh, all of them. Friday, Saturday, and Sunday.
Where did that conference take place?
Every year we get the Hampton Hotel in Freeport.
Now, did you have any particular responsibilities at the conference that year?
That year, I was actually technical coordinator. Now I had a lot of responsibilities. I made the official conference pamphlet. I set up all the PowerPoint presentations. I even introduced the keynote speaker.
Mr. Cononova, do you ever recall seeing Mrs. Perry at the conference that weekend?
Oh, certainly. Tyler had filled in for Ryan Reynolds. She was actually running the conference.
Where specifically did you see Mrs. Perry?
We were working together in the first floor.
Mr. Cononova, at any time on either Saturday or Sunday, do you recall ever seeing Mrs. Perry leave the first floor where that conference took place?
No. Tyler was working with us the whole time.
Thank you, Mr. Cononova. No further questions at this time, Your Honor.
Okay, cross-exam.
Yes, Your Honor. May I proceed?
Yes, you may.
Good afternoon, Mr. Cononova.
Good afternoon.
Mr. Cononova, you've known the defendant, Mrs. Tyler Perry, since you two were children. Is that right?
Yes.
In fact, you and Mrs. Perry have been extremely close from the time that you were very young.
We did grow up together.
And you would characterize your relationship with Mrs. Perry as extremely close, wouldn't you?
Yes.
Mrs. Perry even helped you to get your current job at Fitz Enterprises, didn't she?
She did put in a good word.
Now, Mr. Cononova, over the weekend of October 22nd to 24th, 2004, you were present at a Fitz Enterprises conference, right?
I was, yes.
And that conference took place at the Hampton Hotel?
Of course, yes.
Now, you just testified on direct that throughout that conference, you never saw Mrs. Perry anywhere but the first floor, right?
We were working together on the first floor, yes.
But Mr. Cononova, you didn't spend every single minute of that weekend with Mrs. Perry, did you?
Oh, every minute? Probably not.
Now, you were also aware, back in October of 2004, that Mrs. Perry's husband had been diagnosed with a potentially lethal brain tumor. Is that right?
Tyler did tell me that, yes.
The defendant also told you that the only hope to cure her husband lay in an experimental surgical procedure, right?
That's correct.
She told you that that procedure was very expensive?
She did.
And she told you that finding the money for that procedure would be nearly impossible, didn't she?
That's right.
Now, you were also interacting with Mrs. Perry on a close to daily basis around that time, right?
Well, that's correct.
You were able to observe her actions while at work?
Absolutely.
And based on your observations, you would say that Mrs. Perry at that time appeared desperate to you, wouldn't you?
Objection, Your Honor. Calls for speculation as to Mrs. Perry's state of mind.
Overruled.
Would you like me to repeat the question?
No, that's fine.
You may repeat it. Go ahead.
Based on your observations at that time, Mrs. Perry seemed desperate to you. Would you agree with that?
I would say so.
She seemed visibly agitated?
Before she received that job offer from Holly Publishing, absolutely.
Close to the time of the kidnapping, Mrs. Perry seemed visibly agitated to you. Is that right?
That's right.
She also seemed anxious to you at that time. Is that correct?
She did.
Right. Now, back in October of 2004, Mrs. Perry was also in line for a job promotion at Fitz, right?
She was.
And Ryan Reynolds was going to be making the decision regarding that promotion, correct?
That's also right.
Mrs. Perry was denied that promotion, wasn't she?
She was.
And you observed her behavior after she was denied that promotion, right?
I did, yes.
And according to your observations, upon not receiving that promotion, Mrs. Perry appeared enraged, didn't she?
That's right.
You tried to console her, right?
Well, of course. I tried to be there for Tyler as best as I could.
And when you tried to console Mrs. Perry, she yelled at you, didn't she?
She did.
She yelled at you, "Don't tell me how to run my life." Is that right?
She said that.
And then Mrs. Perry said to you, "Casey is going to get the money for that operation one way or another." Isn't that right?
That is right.
Now, about a couple weeks after that was when Mrs. Perry came into your office with that letter in her hand, right?
I believe so, yes.
And that letter, Mrs. Perry said, demonstrated that she had a job offer from Holly Publishing Company. Is that right?
That is correct.
You were also aware, based on what Ms. Perry told you, that that job offer would not be able to come into effect for a period of 6 months. Isn't that right?
I believe Tyler did mention that.
All right. Now, you testified on direct examination that you told Mrs. Perry that day that if she were to receive a job with Holly Publishing, their insurance would cover her husband's surgery. Is that right?
Casey's operation was covered. Now, that's correct.
But you also told Mrs. Perry that Holly has a history of rescinding their job offers, didn't you?
I did tell Tyler that.
And the day that you told Tyler that Holly has a history of rescinding their offers was October 20th, 2004.
That's right. That was when the conversation took place.
Thank you. No further questions.
Any recross, redirect?
Yes, Your Honor. Well, Mr. Conover, I just want to clarify an issue of timeline that came up on cross-examination. You were asked several questions about Mrs. Perry seeming anxious and agitated in early October of 2004. Did Mrs. Perry ever seem anxious after you told her husband's operation would be covered?
After our conversation? Not once.
Did she ever seem agitated after you told her that operation would be covered?
No.
Mr. Conover, did she ever say anything to you about needing money after you told her the operation would be covered?
After I spoke to her about the operation, not a single time.
No further questions, Your Honor.
All right, counsel, and I want to make this clear to both counsel. As far as the testimony concerning the contents of that letter, I've allowed it in for the limited purpose as it reflects on the defendant's state of mind. It is not being introduced for the truth of what appears in that letter.
Yes, Your Honor.
And I presume you'll argue accordingly.
Yes, Your Honor.
All right, thank you. Thank you, sir.
Thank you, Your Honor.
Do you have another witness?
Yes, Your Honor. At
Please.
this time, the defense calls Jordan Nathanson to the stand. May I proceed?
Yes, you may.
Do you please state your name and spell your last for the record?
Sure. My name is Jordan Nathanson. That's Nathanson.
Mr. Nathanson, what is your profession?
I'm an investigative auditor. I'm also the founder and managing partner of Nathanson and Associates. It's an office of private investigators located right here in Midlands.
You said you were an investigative auditor. Could you explain for the court what the work of an investigative auditor entails?
Well, investigative auditors are bureau-trained law enforcement supervisors. We both train and assess local detectives across the country.
What does it mean to assess the work of local detectives?
There are mainly two services I can provide for local law enforcement. The first is to provide a second opinion in a given case, an opinion that hopefully helps to steer a complex investigation in the right direction. The other is to provide an assessment of the officers themselves. I'll communicate my evaluation of their work in an investigation to their commanding officers, or when I'm working in the private sector, to an independent client.
Well, Mr. Nathanson, as an investigative auditor, do you conduct investigations yourself or interview witnesses yourself?
No, ma'am. It's purely a protocol assessment. I don't re-interview witnesses or reopen the investigation, though I might recommend that to the local police. Instead, I'm looking at investigators' methods, determining whether or not those methods conform to a standard protocol.
Could you outline for the court any educational background or experience you have to qualify you for those kinds of assessments?
I have bachelor's degrees in biochemistry and psychology from Bowling Green. My master's is in biochemistry from Michigan. After that, I went to the FBI Academy. I spent 3 years there in the behavioral sciences and forensics unit.
And what did your training at the FBI Academy consist of?
Well, it's a combination of classroom work and field training. The entire program is focused around proper investigative techniques. So we take courses in everything from advanced forensics to criminal psychology to interrogation procedures. We then couple that classroom work with applied training in the field.
What did you do after graduating from the FBI Academy?
I took a job with the Bureau. I spent 25 years there in the behavioral sciences and forensics unit.
Mr. Nathanson, do you belong to any professional organizations in your line of work?
Yes, ma'am, I do. I'm a member of the Midlands Law Enforcement Training and Standards Board.
What do you do as a member of the Midlands Law Enforcement and Training Standards Board?
Well, Standards Board puts together the MIM. That's the Midlands Investigative Manual. It details investigative protocol for every officer in this state. It covers everything from evidence collection and handling to field interview techniques. We meet every year to update that manual for new situations, new technologies that might arise.
Mr. Nathanson, I'd like to turn your attention now to the case before the court today. Now, how did you become involved in this case?
Well, I was hired by the Reynolds family. They retained me as a private consultant to provide an independent assessment of the evidence in their daughter's case, and also to oversee the work of local police, basically to make sure that local detectives were following proper protocol.
You said you were hired by the Reynolds family. Are you still being paid by the Reynolds?
No, ma'am. My contract with the Reynolds ended when I provided them my conclusions in this case.
Are you being compensated by anyone for your time in court today?
No, ma'am. I was subpoenaed to testify.
Well, earlier you mentioned that in your job as an investigative auditor, you review the evidence that's collected by local detectives. Now, how did you get access to the evidence in this case?
Well, I have a good working relationship with Detective Walsh, the lead investigator on this case. I was forwarded evidence as it was collected by local police. And when they wrapped up their investigation, I got a complete copy of that case file.
I'd like to ask you about a couple of specific pieces of evidence in this case file. Did you ever review the chemical evidence that was found in Mrs. Perry's car?
Yes, ma'am, I did.
Do you have any experience with the chemical chlorandramine and its uses in crimes like this one?
I do. The FBI provides training in chemical analysis and chemical testing for a variety of chemicals often used by criminals. Chlorandramine is commonly used in cases where the victim is incapacitated.
Mr. Nathanson, have you ever received training in how to conduct or interpret the tests that are used to detect the presence of chemicals like chlorandramine?
I have. It's a standard spectroscopy test.
Now, at this time, may I have permission to approach the bench to retrieve previously admitted evidence, States 4?
Yes, you may.
Thank you. The same report, DNA and chemical analysis report. Thank you. May I approach the witness
Yes,
for the
you may.
document as well? Handing Mr. Nathanson what has been entered into evidence as States 4. Mr. Nathanson, do you recognize the document I've just handed you?
Yes, ma'am. This is the DNA analysis and chemical analysis report from the evidence found in Mrs. Perry's vehicle.
Based on your familiarity with the tests that are indicated in that document, can you tell us whether the document indicates how the chlorandramine got into Mrs. Perry's car?
No, ma'am. This sort of test merely suggests that Mrs. Perry came into contact with the substance at some point before getting into her vehicle. But whether or not she was herself involved in the crime or merely came into contact with the chemical some other way, now that's something that this sort of test simply cannot show.
Objection, Your Honor. Lack of foundation.
Basis?
Your Honor, this witness has been trained in how to conduct, I'm sorry, Your Honor. I'll defer to opposing counsel.
Yes, Your Honor.
I have to confess, I misled you. Basis.
Yes, Your Honor. Yes. Your Honor, the witness has testified that he does understand the chemical processes used to test the presence of chlorandramine on the surfaces involved. However, he has not testified to any experience or data that would lead him to the conclusion that that chemical could be moved around by the processes of garments interacting or anything else as he is suggesting. There is a step between the chemical presence of chlorandramine on those surfaces and whether or not that chemical presence indicates Tyler Perry's involvement with chlorandramine, and no data or evidence has yet shown that he can cross that gap.
May I respond, Your Honor?
Yes, you may.
Your Honor, that would go to weight and not admissibility. That can be addressed on cross-examination. We have laid the proper foundation at this time that the witness has the necessary skills, knowledge, or experience to be able to testify to this. As he's seen chlorandramine used before in the commission of crimes he's investigated, and has also received training in how to conduct and interpret the very same tests run here.
Thank you. The objection is overruled. Proceed.
Mr. Nathanson, by looking at that document, is it able to show you how the chemical chlorandramine got into Mrs. Perry's vehicle?
No, ma'am, it is not.
Well, Mr. Nathanson, in your review of the case file here, did you find any other indications of an alternate explanation for how the chemical might have transferred?
No, ma'am. Without more extensive testing on other surfaces in the home, I simply can't account for the chlorandramine under any one theory of this case.
Your Honor, at this time, may I have permission to approach the witness and the bench in turn to retender the evidence?
Yes, you may. Thank you.
Mr. Nathanson, the other thing that you mentioned you do as an investigative auditor is assess the work of local detectives. Did you conduct a protocol assessment in this case?
Yes, ma'am, I did.
Well, I'd like to ask you about some of the specific findings of that protocol assessment. Now, first, could you outline for the court the way that an investigator should differentiate between witnesses and suspects in a criminal case like this one?
Well, anyone with information about a given case is considered a witness, but when the evidence demonstrates that someone has means, motive, or opportunity, that person instantly becomes a suspect. The main difference in our eyes is that a suspect is somebody who may be intentionally withholding information. Because of that, we treat them very differently throughout the process.
You mentioned that suspects might be withholding information. Now, what are the proper procedures that police should use to uncover that information?
Mainly two approaches that we can take. The first involves an interrogation, a much more adversarial process than a simple field interview. The suspect is brought out of their normal environment. They're brought down to the station, and they're extensively questioned. The second involves the use of search warrants. We use those warrants to try to obtain physical evidence a suspect may be withholding.
Well, Mr. Nathanson, earlier in today's case, Detective Walsh admitted under cross-examination that he had never interrogated Peyton Braylow or searched her home or car. Based upon your experience as an auditor and your review of this case file, is that consistent with proper protocol?
No, ma'am, it is not. In an investigation with multiple suspects, protocol requires that each suspect be investigated fully. Those steps are not taken, key questions in a case may continue to go unanswered, leaving us with suspects who cannot be ruled out.
No further questions, Your Honor.
Right.
May I proceed?
Yes, you may.
Good afternoon, Mr. Nathanson.
Good afternoon.
Now, Mr. Nathanson, you testified that you conducted an investigative audit in this case. Isn't that true?
That's correct.
And the investigation that you audited was that conducted by Detective Donnie Walsh. Isn't that true?
Yes, the kidnapping of Bailey Reynolds.
Now, you mentioned on direct testimony that this involves overviewing the evidence that's put together by local law enforcement agencies and assessing whether that evidence and the manner in which it is collected is consistent with the rules. Isn't that true?
That's precisely right.
Now, you received a case file in this case. Isn't that true?
Yes.
And the case... Go ahead, please.
Well, it did not include everything that Detective Walsh had. It included several witness affidavits, as well as several criminal reports and evidence reports in this case.
Now, the affidavits that it included were, of course, written by the witnesses. Isn't that true?
Yes, sir.
They were signed by the witnesses, correct?
Yes.
You did not receive transcripts of the conversations between the members of the Fairfax County Sheriff's Department and these witnesses, did you?
That's true.
So if those, for a hypothetical, if those interviews were to contain more information than were present in the affidavits, you wouldn't be aware of this information, would you?
Well, that's not really correct. Under standard police protocol, Detective Walsh should be required to include any relevant information in his affidavit or in his police report, and I received both copies from him.
That's true, but the affidavits that are written by the witnesses don't necessarily, by standard police protocol, have to include all the information that the witness knows, right?
We can't be sure of that. That's true.
So if the witness were to know more information than he or she included in his affidavit, then that might not make it into your case file. Isn't that true?
That could be true, yes.
Now, you're not aware of the fact that Peyton Braylow doesn't own a vehicle, are you?
I don't know whether or not she owns a vehicle. That's true.
And you are aware that a vehicle would be required to transport a kidnapped victim by car, aren't you?
That's true.
You believe that Peyton Braylow should be looked into further as a suspect by the Fairfax County Sheriff's Department, don't you?
Yes, the fact is, we don't know whether or not she operated alone, worked with others, or was involved in this crime in any way.
And yet, without a vehicle, Peyton Braylow could not be a likely suspect for a vehicular kidnapping, could she?
That's true.
Now, let's talk about the forensic evidence that you looked over. You looked over forensic evidence including fingerprint reports, isn't that true?
Yes, I did.
And you believe that in some cases, the police did not follow standard operating procedure in this investigation, isn't that true?
Several places, yes.
Now, you would say, for instance, that the fingerprint placed on the ransom note was not according to standard police operations, isn't that true?
Of course not. Touching evidence without gloves can contaminate that evidence and render it unusable later in the investigation.
But you weren't present in the Reynolds home when Detective Donnie Walsh found that ransom note, were you?
No, I was not.
You weren't present when Deputy Budzik touched it, were you?
That's correct.
You couldn't overview any of the means or the measures that these two detectives took in that investigation, could you?
No, all of that would be documented in Detective Walsh's affidavit.
Right, but to be clear, you weren't present and don't have personal knowledge of that investigation, do you?
That's absolutely true.
In fact, to be honest, you don't have personal knowledge of any of the personal forensic investigations that the Fairfax County Sheriff's Department conducted. Isn't that true?
That's right. My audit is purely an observational measure.
Next, let's talk about motive. You believe that Peyton Braylow should have been considered a suspect and not simply a witness by the Fairfax County Sheriff's Department. Isn't that true?
Absolutely. The fact is, Peyton Braylow may have had access to a vehicle that could have allowed her to obtain this crime.
And you believe that Peyton Braylow has a possible motive for the monetary incentive of kidnapping. Isn't that true?
Yes, she does.
You are aware that Peyton Braylow had a debt to the state, aren't you?
I am aware of that.
Your Honor, may I approach the bench to retrieve evidence? Thank you. Your Honor, let the record reflect that I am approaching the witness with what has previously been marked as defense 4?
Defense, what number?
We're not sure, actually.
Letter.
My
Like a
apologies.
B to me,
Your Honor.
counsel?
Sure, that's a B. Now, according to this document, Peyton Braylow's debt to the state was $50,000 at the time that it was ordered. Isn't that true?
Yes, sir, it was.
But it was being paid at a yearly rate. Isn't that true?
Yes, the question here is who was paying it. This doesn't show whether or not Peyton Braylow was paying it herself or receiving help, in which case we don't know exactly how much she owed at the time of the kidnapping.
Regardless of that, Mr. Nathanson, the debt was being paid at a rate of $10,000 per year. Isn't that true?
Yes, it was.
And it was being collected on the 1st of October each year. Isn't that correct?
Up through 2004.
And Peyton Braylow had already satisfied $30,000 of the $50,000. Isn't that correct?
That's correct.
And the next payment was to be due on the 1st of October in 2005. Isn't that true?
That's not correct. The payments aren't necessarily due on any particular date.
But the first payment was due on the 1st of October in 2002, correct?
These aren't due dates. These are just dates that it was paid.
The first payment was made on the 1st of October in 2002, correct?
Yes, it was.
And the second payment made on the 1st of October in 2003?
Yes.
And Mr. Nathanson, that third payment, it was made on the 1st of October in 2004, isn't that true?
Yes, it was.
So it seems reasonable to imagine that the fourth payment would be turned in on the 1st of October in 2005, isn't that true?
I think that would
Actually,
be...
it calls for speculation.
Overruled.
It seems reasonable to assume that the next payment would be due on the 1st of October in 2005, isn't that correct?
I have no idea.
Certainly. Now, Mr. Nathanson, let's talk about the motive of Tyler Perry in this case. You are aware that Casey Perry was diagnosed with a deadly brain tumor, aren't you?
Yes, I am.
You're also aware that doctors informed Mr. Perry that if he did not receive a $300,000 operation, he would face peril. Isn't that true?
Yes, I am.
In fact, within 2 years of his diagnosis, doctors said Mr. Perry would die if he didn't receive this surgery. Isn't that true?
Yes, I believe the original prognosis was about 2 years. Now I believe he is in full recovery.
Now, you're aware that this diagnosis was made in November of 2003. Isn't that true?
That sounds about right. I don't recall the exact month.
And that would mean that without this surgery, Mr. Perry would die by November of 2005. Isn't that true?
I'm really not a doctor.
But adding 2 years to November of 2003 would give us November of 2005. Isn't that correct?
Yes, it would.
And that would mean that if health insurance were not to cover this surgery, Tyler Perry would need $300,000 by November of 2005. Isn't that true?
If all those facts are right, that would be correct, yes.
And Peyton Braylow, as we just said, would need $10,000 by November of 2005. Isn't that true?
Again, these aren't due dates, counsel. These are just dates that previous payments were made.
But just to be clear, according to the assumptions that we've made, which you have agreed along the way have seemed reasonable, Tyler Perry would need $300,000 by November of 2005.
Your Honor,
Peyton Braylow would need
at this time,
$10,000.
I'd object to the relevance of this line of questioning.
I'm going to sustain the objection, and those are things you can't argue.
Certainly. Certainly. Next, let's talk about the chemical evidence that you examined. You're aware that chlorandramine was used in this case, aren't you?
Yes, I am.
And you are aware that chlorandramine was used to sedate Bailey Reynolds?
Yes, it was a barbiturate used to incapacitate her during the time of the kidnapping and throughout the weekend.
It was found on Bailey Reynolds' pillow, wasn't it?
Yes, it was.
And when she
in
was
Mr. Perry's vehicle.
Certainly. And when it was recovered in room 312 of the Hampton, when she was recovered from room 312 of the Hampton Hotel, it was found in her bloodstream. Isn't that true?
That's right. Hospital reports indicated that.
Now, you have reviewed the drug charges against Peyton Braylow, haven't you?
Yes, I've reviewed this.
These drug charges relate to a type of drug called a methamphetamine. Isn't that true?
Yes.
Now, that, of course, is not the same as a barbiturate, is it?
No, I think the point here is that it's in a similar family of drugs that are manufactured on a regular basis by criminals intending to distribute them. And the same equipment is actually used to make both drugs.
But, Mr. Nathanson, just to be clear, nowhere on that document is chlorandramine referenced, is it?
No, they are two different subtypes.
And Peyton Braylow did not plead guilty to possession of any illegal drug in this case, did she?
Not in this case. It's a different drug, that's true.
Now, you're also aware that Tyler Perry did use chlorandramine, or at least was exposed to it during the course of this event. Isn't that true?
Sorry, I'm not sure I understand your question.
You're aware that chlorandramine was found in 3 separate places of her vehicle. Isn't that true?
Yes, it was.
On the steering wheel?
The steering wheel and the driver's side doors, both the rear door and the front door on the left side.
You're also aware that Tyler Perry knew what chlorandramine was, aren't you?
No, that's not really the case.
Did you review the case file in this case?
I did review the case file, yes.
As part of that case file, did you review Detective Donnie Walsh's affidavit?
I did review that affidavit, yes.
Then you must be aware, Mr. Nathanson, that in Detective Donnie Walsh's affidavit, the same document you previously said would include all relevant information that Donnie Walsh found. It mentioned that he had found an article written by Tyler Perry about chlorandramine. Isn't that true?
Objection, Your Honor. Calls for hearsay. Mr. Walsh's affidavit, or Detective Walsh's affidavit, is not admissible in court at this time, and this would be an out-of-court statement being offered to prove the truth of the matter asserted. If opposing counsel wanted to inquire into this, they should have done so on the direct examination of Detective Walsh.
How do you respond?
May I respond?
Yes.
This evidence is not going to the truth of the matter asserted, or that Detective Donnie Walsh actually did personally find this article, but instead is going to the weight of this witness's investigation. He has testified that he reviewed a case file, and that case file included an affidavit, and that all relevant information that he has used in his investigation came from that affidavit. We are simply ascertaining whether or not he is aware of a fact that's in the same affidavit he's been talking
Do you
about.
have a response?
Yes, Your Honor. I believe opposing counsel would be arguing Rule 703, offering this as underlying facts or data for Mr. Nathanson's conclusions. However, under Rule 703, it makes very clear that evidence that is otherwise inadmissible may come onto the record only if it is more probative than prejudicial. But here, that article would be highly prejudicial. May I make an offer of proof to explain that?
The objection is overruled. Proceed.
So, Mr. Nathanson, you are aware that Detective Donnie Walsh found an article written by Tyler Perry about chlorandramine, aren't you?
Well, that's not correct. In fact, the article that he's mentioning, it refers to a college article written about 20 years ago. It was about date rape drugs written for Tyler Perry's school paper. And in that article, she mentions chlorandramine once. On the basis of that, Detective Walsh concluded that she had knowledge of chlorandramine at the time of the kidnapping. That's simply a leap I am not willing to make.
But your answer to my question is yes, you're aware that Detective Donnie Walsh found this article. Isn't that true?
I'm aware he found that article, yes.
Your Honor, permission to approach opposing counsel? And permission to approach the witness. I'm now handing you the article we've been discussing. This is an article written for a newspaper, isn't it?
I don't know. I've never seen this article before.
You've never seen this article before, Mr. Nathanson?
No, I have not seen this particular article before.
Okay, but it is an article written for a publication, isn't that true?
It appears to be so.
And it appears to be authored by a person named Tyler Perry, isn't that true?
That's what it says.
The title of the article is Having a Connection, isn't it?
Yes.
And the article mentions the drug chloroandramine, doesn't it?
Objection, Your Honor. This calls for hearsay.
Overruled.
The title of that article is Having a Connection, isn't it, Mr. Nathanson?
Yes, it is.
Thank you, Your Honor. May I approach the witness? Your Honor, at this point, I move to enter what has previously been marked as the article in question. And I'll be happy to give it a more clear marking at this time.
Do you have any response?
Yes, Your Honor. At this time, we'd renew our objection that this is more prejudicial than probative. Here, the article is from over 20 years ago, and its prejudicial value to Mrs. Perry is extremely high, as it mentions several other drugs that have no relation to today's case. The probative value is so far diminished by the time that has elapsed from the time that Mrs. Perry wrote the article to the time of the kidnapping that the prejudicial value far outweighs it.
I'm going to overrule your objection. I'm going to allow it.
Thank you, Your Honor. Now, Mr. Nathanson, you believe that the chemical evidence in this case is inconsistent with your finding, isn't that true?
No, my conclusion is that I can't explain how the chemicals got into her car under any explanation in this case.
And Mr. Nathanson, you were dismissed by Ryan Reynolds before you could conclude your investigation, isn't that true?
When I told Ryan Reynolds that I didn't believe Tyler Perry had committed this crime, they did fire me.
Thank you, Your Honor. No further questions for this witness.
Redirect.
Yes, Your Honor. Honor, before I begin, may I have permission to approach the bench to retrieve several documents? Retrieve the article.
You want this last one?
Yes, Your Honor. And also the criminal records report, marked as Defense B.
I believe I still have that.
The witness still has it. May I proceed?
Thank you.
May I approach the witness? Handing Mr. Nathanson the document that has just been entered into evidence. Mr. Nathanson, could you read the date on that article from Mrs. Perry?
Yes, February 6th, 1985.
Could you also reference the criminal records report from Peyton Braylow, the document that's been entered into evidence as Defense B? Could you read the date of Ms. Braylow's conviction?
Her conviction occurred on January 8th, 2002.
Finally, Mr. Nathanson, the second thing I'd like to direct your attention to are some questions you were asked on cross-examination about Ms. Braylow's access to a car. Now, in your experience as an investigative auditor, who is responsible for determining whether or not suspects have access to vehicles?
Well, simple DMV check can reveal that in a second.
Are investigating officers responsible for determining whether or not suspects in criminal cases have access to automobiles?
They absolutely are.
In your review of the case file here, did you find any indication that Detective Walsh had looked to see if Peyton Braylow owned an automobile?
Yes, ma'am, I looked at the case file and realized that Detective Walsh had done no such thing. At no time did he determine whether or not Peyton Braylow had access to a vehicle of her own or access to someone else who has a vehicle who might also be a suspect in this case.
Nothing further, Your Honor.
Thank you. You may step down. Thank you. Are there any other witnesses?
Yes, Your Honor. At this time, the defense calls Mr. Francis Gustavo to the stand. Please state your name and spell your last for the record.
Francis Gustavo, Gustavo.
Where do you live, Mr. Gustavo?
I live right here in Evanston.
What do you do for a living?
Well, for generations, the Gustavos have owned and operated Freeport's fine liquors. Now, we're the only vendor of fine wines, spirits, mixed drinks, and moonshine in Freeport. And since Evanston is dry, the entire county comes knocking on our door whenever there's a soiree.
You mentioned that you lived in Evanston. About how long does it take to drive from the city limits of Evanston to the liquor store in Freeport?
Well, I make that drive every morning from the McDonald's at the downtown mall. I just climb on the interstate. That takes 20 minutes.
And during what hours is Freeport's Fine Liquors open?
Well, I come into the store after breakfast, about 11 o'clock, shut down the store for lunch between the hours of 12 and 3, come back for the afternoon.
Objection to relevance, Your Honor.
Overruled.
What I was just saying is, I come back for the afternoon, I shut down the store again for dinner. between 6 and 7:45. I'll reopen the store by 8, keep it open till about 11, just in time for my dessert.
Mr. Gustavo, was your store open on the night of Friday, October 22nd, 2004?
Absolutely, yes.
And do you know an individual named Tyler Perry?
Well, sure. Tyler and I went to Evanston High together. We didn't know each other very well. Didn't really run in the same circles, but I see him in the store now and again, and we'll catch up on old times.
Do you recall seeing Mrs. Perry inside your store on the night of October 22nd?
Well, yes, she came in that night.
Did she make a purchase that night?
She did. She bought a bottle of wine.
Do you keep copies of receipts that customers make from purchases customers make at your store?
Oh, of course. That's SOP, Standard Operating Procedure. That's what we call it. Customer makes a purchase, we provide them with a receipt, keep a copy for ourselves.
Your Honor, permission to approach opposing counsel?
Name?
I'm showing opposing counsel a copy of what has been marked for identification as Defense Exhibit C. Permission to approach the witness?
Yes, you may.
I'm now approaching the witness and handing him a copy of that same document. Mr. Gustavo, do you recognize what I've just handed you?
Of course. This is a receipt that you, received when you shop with us at Freeport's Fine Liquors. This is Mrs. Perry's receipt from that night.
Is it a fair and accurate copy of the receipt you gave Mrs. Perry?
Yes, certainly seems to be.
Did you provide a copy of that receipt to the police?
Yes, I did.
And are there timestamps on your receipts from Freeport's Fine Liquors?
Yes, of course.
Do you have any reason to believe that those timestamps are accurate?
Oh, sure. Actually, every evening I'll make sure to synchronize the times on the clock and the register in the store when I'm watching my favorite program, Larry King Live on CNN. They got the time right there on the corner of the screen, so it's very convenient.
Your Honor, this time we'll offer this document into evidence as Defense Exhibit C.
Is there any objection?
No objection, Your Honor.
May be received.
Permission to approach and tender?
Yes, you may.
Thank you, Mr. Gustavo. Here you go, Your Honor. Mr. Gustavo, what happened after Mrs. Perry entered your store that night?
Well, she headed to the back of the store, grabbed a bottle of wine, and then headed back to the front to stand in line.
How long was your line that evening?
Well, we had a very busy night. I remember I had to go to the back and get a couple kegs for a few customers. I was huffing and puffing quite a bit, not moving real fast, but as soon as I got back up, I noticed Mrs. Perry in the line.
Did you see Mrs. Perry standing in that line?
I did.
Could you describe for the court how Mrs. Perry was behaving as she stood in line that evening?
Well, she certainly seemed to be in a rush a bit. Kept checking her watch once or twice, glanced out the window, looked at her car.
You mentioned that she glanced out at her car. Could you see Mrs. Perry's car from where you were standing inside the store?
Well, sure. I was standing right there at the register. I could see it parked right outside the store.
Did you yourself see anyone inside Mrs. Perry's vehicle, with the exception of Mrs. Perry herself?
Oh, no. The only person I saw in that car was Mrs. Perry.
Mr. Gustavo, you also said this was a busy night. Did any of your customers come into Freeport's Fine Liquors and say that they saw someone inside Mrs. Perry's vehicle?
No. No one ever said anything of that kind.
Mr. Gustavo, what happened after Mrs. Perry paid for her wine that night?
Well, at that point, I provided her with a receipt, and she headed out the door.
Do you remember what time Mrs. Perry entered your store that night?
Well, I don't know the exact time, but I know it was around 9:45 that night.
And around what time did Mrs. Perry leave Freeport's Fine Liquors that night?
Just a couple minutes after 10, just after she made her purchase.
Thank you, Mr. Gustavo. No further questions, Your Honor.
Thank you. Cross.
Yes, Your Honor. Permission to set the courtroom before proceeding.
Your Honor, before opposing counsel begins, may I have permission to move so as I can see the demonstrative?
Yes.
I inquire, Your Honor.
Yes, you may.
Mr. Gustavo, you stated that Tyler Perry arrived at your store around 9:45 p.m. Isn't that right?
Oh, that's Gustavo. Yes, around then.
But you can't be sure what time she arrived, can you?
No, I don't know the exact time.
Now, when she came into your store, she immediately rushed to the back, didn't she?
That's right.
Then she grabbed a bottle of wine off the shelf, right?
That's right, a regular Romani Conti.
She grabbed it so quickly that it seemed to you as though she didn't even look at the label. Isn't that right?
It seemed like that, yes.
And then she rushed up to the front, didn't she?
That's right.
And then she paid, right?
Yes.
So Miss Perry was actually rushing the entire time she was in your store, wasn't she?
Yeah, other than standing in line for a bit, sure.
So isn't it in fact true, sir, that she was only there for a few minutes in total?
10, 15, sure, a few minutes.
Only a few minutes in total, isn't that right? You would characterize it as a few, yes?
Sure.
And you aren't sure when she arrived, just to be clear.
I only know it was around 9:45.
But you know she left at 10:02.
That's right, yes.
Now, Mr. Gustavo, you've seen Tyler Perry in your store on a number of occasions, haven't you?
Sure, she comes in. She's a regular.
So you've seen how she behaves on many different occasions, isn't that right?
Sure.
And you would say, wouldn't you, that there was something different about how she was behaving this time compared with all the other times you've seen her, wouldn't you?
That's right. Usually she does spend a little longer in the store.
Usually she'll speak with you, won't she, while she's in your store?
Sure, well, a lot of my customers say I'm a bit talkative, but yes, usually we do.
But this time Miss Perry rushed in without saying anything to you, didn't she?
That's right.
And this time, when she was waiting in line, you saw that she was constantly looking out to her car, isn't that right?
Yes.
You saw that she was checking the time all the time, didn't you?
She looked at a watch, yes.
You saw that she was fidgeting, isn't that right?
She seemed to be, yes.
You saw that her arm was even twitching, didn't you, Mr. Gustavo?
I would say so.
And in fact, on the whole, you would characterize Miss Perry's behavior as off-kilter that night, wouldn't you?
I would, yes.
Now, Miss Perry came into your store to buy a bottle of wine, you said, isn't that right?
Oh, of course. Well, not just any bottle. You see, Romani Conti was very delicious.
So she bought one bottle of wine, right?
That's right.
Now, isn't it true that her husband had come in a few days prior to this?
That's right. Casey had come in.
And when Casey came in a few days before, he also bought wine, isn't that right?
That's right.
Your Honor, permission to use a map for demonstrative purposes? Mr. Gustavo, you recognize this to be a map of the area surrounding your liquor store, don't you?
Certainly. I can't see it very clearly, though.
Move a bit closer then, sir. This is a map of the area surrounding your store, isn't it?
Certainly seems to be.
Seems to be fair and accurate to you, doesn't it?
Sure, all the buildings are a bit smaller, but yes.
You'd agree that the scale on this map is... You'd agree the scale on this map is accurate, wouldn't you, sir?
I guess so. I'm not sure exactly, but sure.
Now, your liquor store is located here, isn't it?
That's right, there it is.
So it's labeled Freeport's Fine Liquors,
Freeport's Fine, yes, it is.
And the Hampton Hotel is located here, isn't that correct?
That's right.
And the two locations are connected directly by an underpass, aren't they?
That's right.
And you can tell the court today, can't you, that Miss Perry was present at your store at 10:02 p.m. on October 22nd, 2004, can't you?
That's right. That's when she left.
You can tell us that she was in a car at this time, can't you, sir?
I believe so. That's what it looked like she was going to, yes.
Now, you stated that you could see her car from where you were at the cash register, isn't that right?
That's right.
You stated that you couldn't see anyone inside the car, correct?
That's right.
So you couldn't see anyone through the back window, right?
Yes, I couldn't see anyone inside the car.
Now, beneath the back window, sir, was the back door, right?
Yes.
And the door was opaque, wasn't it?
I believe so.
So you couldn't see through the door, could you, sir?
Oh, well, I'm not Superman.
So it's, given that you do not have superhuman powers, sir, you couldn't see whether there was anyone in the car lying on the back seat, could you?
From what I could see where I was standing, I didn't see anything in the car.
So you would agree, sir, that it would be possible for there to be someone lying on the back seat of that car, based on your observations, wouldn't you?
I don't know. All I know is that I didn't see anything from where I was standing.
But, sir, it would have been possible for someone to have been lying on the back seat of that car beneath the area.
Objection, Your Honor. Speculation.
Well, the question has been asked and answered. I'm going to sustain the objection.
Yes, Your Honor. Now, Mr. Gustavo, I'd like to talk about your interactions with the police.
Sure.
They first came to interview you a few days after the kidnapping occurred, isn't that right?
Yes, the first time they came in was on Monday.
And on that occasion, you spoke to the police about what you saw of Miss Perry that night, didn't you?
That's right.
You told them about how she acted, correct?
Yes, I told them anything I knew.
You told them about your interactions with her, isn't that correct?
Of course.
And that's all that you told them on that occasion, correct?
I provided them with any information they wanted, sure.
So that was the only information you provided to them at that time, right?
Yes, anything they asked for.
Now, you then spoke to the police on a second occasion some days later, isn't that right?
Yes, they came in a couple times that week. They came in later that week again.
And in between the first time you spoke to the police and the second time, you read in the newspapers about the kidnapping of Bailey Reynolds, didn't you?
That is when I had learned about it, yes.
And you learned on reading those newspaper articles that Miss Perry had a relationship with the Reynolds family, didn't you?
Yes, I believe so.
And it was only on that second occasion that you decided to give the police the receipt, isn't that correct?
Well, I tried to provide them anything I could. When they came in the second time and asked for it, of course I provided it.
Mr. Gustavo, the police did not ask you for that receipt, isn't that correct?
Not the first time, and once they came in later that week, I gave them anything they asked for.
The police did not ask you for the receipt when they came in for the second time, isn't that correct?
Well, they came in and asked me to give them any information I knew.
Isn't it true, Mr. Gustavo, that the police only asked to see the speaker system in your store on that second occasion they spoke
See the what system, excuse me?
Sorry, Your Honor?
To see what system?
The speaker system. And
Okay.
isn't it true that the police only asked to examine the intercom system that you had set up in your store?
That's right. For the most part, that's what they wanted to know.
So the police did not ask you for any receipt, did they?
No, not specifically any information, but that's right. That's what we mostly talked about.
You volunteered that document, correct?
Objection, Your Honor.
Overruled.
You volunteered that document, didn't you?
Yes, I wanted to give them anything I knew.
And you have known Tyler Perry for some years, haven't you, Mr. Gustavo?
Well, we did go to high school together.
And she's been a regular at your store for some time, hasn't she?
She has.
And this receipt that you gave to the police doesn't actually have Ms. Perry's name on it, does it, sir?
No, none of the receipts I provide have names, that's right.
And when you told the police that you thought it was Ms. Perry's receipt, the reason you gave them for that belief was only that it was Romani Conti wine bought, correct?
That's right. Well, she's the only one of my customers that buys that wine.
Mr. Gustavo, you do have a speaker system, as we mentioned before, in your store, don't you?
I do. A couple years back, I decided to install one and share some of my private collection of Luther Vandross.
And some of this music from your private collection plays at the liquor store, doesn't it?
Oh, of course. I want to share that collection with everyone.
So,
Excuse me, I'm not going to tolerate these outbursts. Now, I may have to remove the courtroom. All of you. So proceed, counsel.
thank you, Your Honor. Music does play outside your liquor store, doesn't it, Mr. Gustavo?
Yes, great music.
Now, you've been present in court today, haven't you, sir?
That's right.
You were present for the testimony of Bailey Reynolds, weren't you?
Oh, I believe so.
And you heard Ms.
Objection, Your Honor.
Will you restate your question, please?
I asked the witness whether he was present for the testimony of Ms. Reynolds.
Overruled.
Your Honor, may I be heard briefly?
You may.
All witnesses were sequestered, I believe, at the beginning of today's trial. So Mr. Gustavo was not present at the time of that.
Well, he'll answer whether he was or not.
Yes, Your Honor.
Thank you.
Your Honor, for clarification, am I to believe that?
Well, I'd ask that you ask him whether he was present and heard the testimony.
Yes, Your Honor.
Go ahead.
Mr. Gustavo, you were present for the testimony of Bailey Reynolds, correct?
Sorry, no, actually, I was only coming in to provide my own.
I see, Mr. Gustavo. Thank you. Nothing further, Your Honor.
Thank you. Redirect?
No redirect, Your Honor.
You may step down. Thank you. Do you have anything else?
No, Your Honor. At this time, the defense rests.
Prosecution, any rebuttal?
Your Honor, in Midlands, it's not customary for the prosecution to present any rebuttal witnesses.
Well, I would have hoped he would have said no.
Your Honor, may we request a brief recess before
Yes, you
closing
may.
arguments? Thank you. And may we have permission to take down the demonstrative
All right,
in that
please.
recess?
Counsel, may proceed.
Yes, Your Honor. Before proceeding, may I request that any time I have remaining be reserved for rebuttal?
Yes, you may.
Thank you. May proceed. On October 22nd of 2004, Bailey Reynolds was wrestled from her bed, bound, gagged, drugged, and dragged from her room. A ransom note was left on her desk demanding $250,000. She was driven 20 miles to the Hampton Hotel, where she was kept for 3 days and 3 nights against her will, wondering when and whether she would ever be released. It's been proven today, beyond any shadow of a doubt, that this crime was felonious kidnapping of the first degree under Section 212.1 of Midlands Penal Code. The question facing us in this courtroom today, then, isn't what crime was committed, but who it was committed by. And that can be answered by answering 3 questions. Who had the motive? Whose means, opportunities, and actions mirror those of the kidnapper? And who does the physical evidence condemn? 3 questions, Your Honours, all with a single answer. The defendant. Her motive has been proven today, most clearly. In the fall of 2004, she knew that her husband required a $300,000 procedure to save his life. She knew that he would be dead within 2 years. And she learned all of this mere weeks before Bailey Reynolds was kidnapped. 1 week before Bailey Reynolds was kidnapped, the defendant was denied a promotion by Bailey Reynolds' father. We know how she felt about this, Your Honours. It infuriated her. She stormed into the Reynolds home and confronted Ryan Reynolds. "Why didn't you give me the promotion?" she shouted at him. "You know I needed the money," she said. "Maybe something terrible needs to happen to your family." And then, Your Honours, mere days, 2 days before Bailey Reynolds was kidnapped, the defendant's final hope crumbled to dust. She learned then from the letter she received from Hawley Publishing that that job she was hoping to receive, her lost hope of saving her husband's life, wouldn't be any help at all. Because she learned that that job couldn't be begun for 6 months. For 6 months, she would have to wait as a tumor lingered in her husband's brain. For 6 months, she would have to let the man she loved continue to suffer. That is not a gamble she was willing to take. And then worse, 2 days before Bailey Reynolds was kidnapped, the defendant spoke to Lauren Conover. And Mr. Conover warned Tyler Perry that that job offer might be rescinded. Her final hope had gone. She was desperate. She needed those $300,000, and she knew who she was going to get them from, Ryan Reynolds. So on October 22nd of 2004, she had the Reynolds over to her home for dinner, knowing, therefore, that they would be away from their home. During that dinner party, she decided to leave, to go out and buy a bottle of wine, to leave her guests alone in her home, to buy 1 more bottle of wine, even though her husband had bought 3 bottles of wine only a few days before. Wine which Detective Walsh found in the defendant's car. She had no reason to go out and buy it. She was creating an excuse to go and commit this crime. And where did the defendant choose to go when she went to buy this wine? Freeport's Fine Liquors, Your Honor. The one store of all this 20-mile radius that happened to be 400 yards from the Hampton Hotel, where Bailey Reynolds was taken to by the kidnapper. Now, we know that Bailey Reynolds was held in the Hampton Hotel for 3 days. She told us that. And we know that while she was present at the Hampton Hotel, she was being fed regularly. The kidnapper, therefore, must have been present at the Hampton Hotel to do this feeding. We know Tyler Perry was. She admitted being there all weekend. Lauren Conover said she was engaged only in Fitz's company business. He claimed to be with her every minute of that time. They were down on the first floor, he said, where the conference rooms were. But we know that's not the entire truth, Your Honor. We know that Miss Perry was also up on the third floor, where Bailey Reynolds was being held prisoner, because Bailey Reynolds heard the defendant's voice right outside room 312. And we know that she wasn't there only for Fitz's company business, because Mickey Scogan saw the defendant at the Hampton Hotel when he was working there. Every night he was working there. And Mickey Scogan told us that he works from 11 p.m. to 7 a.m. Ask yourselves, Your Honors, why was the defendant present at the Hampton Hotel every night that week, every night that weekend, in the middle of the night? She could not have been there only to run the conference. She was there to feed Bailey Reynolds. Now, Bailey Reynolds told us, unfortunately, that she didn't see the kidnapper. The kidnapper never spoke to her. Of course the kidnapper didn't, Your Honor, because this kidnapper must have been someone known to Bailey Reynolds, someone who knew they had to hide her voice, just like this defendant. We know that Bailey Reynolds was transported to the Hampton Hotel in a car. She told us that car was familiar to her, that she was certain she had driven in it before. We know that Bailey Reynolds had driven in Miss Perry's car before. Detective Walsh confirmed as much, because he found 6 strands of Bailey Reynolds' hair in the defendant's car. That was the only hair found there. No one else's. It must have been left there very recently indeed. And Detective Walsh conducted an extensive investigation. It lasted 7 days. He covered 3 different crime scenes. He interviewed dozens of witnesses. He collected physical evidence, forensic evidence from every scene he investigated. Unfortunately, the fingerprint evidence was of no use in this case because the kidnapper was clearly wearing gloves. That's why there were no prints found on the ransom note. The one piece of physical evidence that we can rely on, that we do know was conclusive, was the chemical evidence, Your Honors. That is a chemical signature which links the kidnapper to the commission of this crime more clearly than anything else we have available to us. Chloroandramine. And that drug was found on the defendant's car, in 3 places on that car. On the front door, on the back door, and on the steering wheel. Jordan Nathanson came to the stand today and tells us about his audit of Detective Walsh's investigation. He told us that he couldn't explain the presence of chloroandramine there by any possible reason. Well, that tells us how credible his testimony is, Your Honors, because there is one extremely clear explanation, by far the most likely, in fact, the only one which we could possibly rely upon. And that conclusion is that Tyler Perry left the chloroandramine there when she used it to commit this crime. It was on her hands, her gloved hands, when she kidnapped Bailey Reynolds and when she drove her to the Hampton Hotel. That is clear. Her guilt has been proven beyond all reasonable doubt, and we ask that you find her guilty today. Thank you.
Thank you, Counsel. Proceed.
Yes, Your Honor. None of us can imagine the terror a parent feels upon returning home to find their 13-year-old daughter missing. And none of us can understand what Bailey Reynolds went through in the 3 days before she was rescued. Your Honor, all of us feel sympathy for Bailey Reynolds and her family, and all of us want to find and punish the person responsible. But now, at the conclusion of this trial, with all of the facts and all of the evidence in, one thing is very clear, that everyone involved in this investigation, from the detectives to the district attorneys on down, was so caught up in their desire to find the kidnapper that no one paused to examine the facts. They were blinded by their need to blame. Now, that need to blame someone, anyone, for the tragedy that befell Bailey Reynolds and her family might have been enough to bring the case against Tyler Perry this far. But Your Honor, in this courtroom today, our standards are higher and the prosecution's burden much greater. They had to prove to you that Tyler Perry, a woman who has been neighbors and friends with the Reynolds family for years, would be capable of kidnapping their daughter. And they had to prove to you that the evidence in this case shows beyond a reasonable doubt that she did so. Your Honors, that is a very high burden, and one that the state has simply failed to meet today. Now, at the beginning of this trial, we stood before you and asked you to keep in mind 3 questions as you listen to the facts and testimony today. First, did Tyler Perry have a motive to commit this crime? Second, did Tyler Perry have time to kidnap Bailey Reynolds on the night of October 22nd? And third, does the physical evidence in this case point exclusively to Mrs. Perry? Your Honors, it is clear that the answer to each and every one of those questions is no. Now, taken in isolation, any one of those questions would be enough to raise reasonable doubt with regards to the prosecution's case. But taken together, they make it impossible for the state to have met their burden today. We'll start with the first question. Did Tyler Perry have a motive to commit this crime? Absolutely not. We heard today from Lawrence Conover, the Director of Human Resources at Fitz Enterprises, who told you that he confirmed for Mrs. Perry that she had received a job offer with health care benefits that would cover her husband's operation. Something that he told Mrs. Perry on October 20th of 2004, 2 days before Bailey Reynolds was kidnapped. As of the night of October 22nd, Tyler Perry did not need money for her husband's operation. She had no reason to commit this crime. That brings us to our second question. Did Tyler Perry even have time on the night of October 22nd to kidnap Bailey Reynolds? Your Honor, we know that Mrs. Perry was absent from her home for about an hour. She left shortly after 9:15, and she returned home at about 10:20. Now consider the testimony of Francis Gustavo, the liquor store clerk and owner of Freeport's Fine Liquors. He told you that it takes at least 20 minutes to drive from Evanston, where Mrs. Perry lives, to the liquor store in Freeport. He told you that Mrs. Perry came into his store around 9:45, and we know from the receipt and evidence that Mrs. Perry didn't leave until sometime after 10:02. 9:45 to 10:02. That's a period of about 17 minutes. That's 20 minutes to drive to the liquor store, about 17 minutes inside, and 20 minutes home. Your Honor, that's all the time that Mrs. Perry was gone from her home on the night of October 22nd. Now, in their cross-examination, the state tried to confuse the issues by questioning how certain Mr. Gustavo was that Mrs. Perry came into his store at exactly 9:45. But, Your Honor, in a criminal proceeding like this one, the burden rests in one place and one place only, and it is squarely on that table. The state hasn't offered you a coherent and logical timeline for the events of October 22nd, 2004. And if they believe that that timeline is not as complete as it could be, that Mr. Gustavo can't tell you every minute precisely that Mrs. Perry was in his store, well, then the state has no one to blame but themselves. Moreover, keep in mind what we learned about the police investigation of Freeport's Fine Liquors. We learned that when the police first came into that store, they never even requested a copy of Mrs. Perry's receipt that night. And why? Because they were blinded by their need to blame. Mr. Gustavo had to offer to provide it to them on their second visit. So let's consider the third question. Did the police ever investigate the last person seen with Bailey Reynolds before she was kidnapped? Peyton Buelo, the Reynolds' own babysitter. Keep in mind what Evanston detectives knew about Mrs. Perry and knew about Peyton Braylow when they started focusing on Tyler Perry as their main suspect. Detective Walsh told us he knew 3 things when he started to focus on Mrs. Perry: that she seemed to have a motive, that she was absent from her home on the night of the kidnapping, and that she had a connection to the Hampton Hotel. A motive? We've shown that Mrs. Perry had no motive. And yet we know that Ms. Braylow had a $20,000 criminal debt that she had yet to pay as of the night of October 22nd, 2004. Absence from the home? We've already shown that Mrs. Perry only went to the liquor store and back on the night of the 22nd. Peyton Braylow was alone in the Reynolds home from the time that they went over to Mrs. Perry's home for dinner until the 911 call was placed after 11 o'clock, a period of several hours, with not a single other individual who can account for her whereabouts. And a connection to the Hampton Hotel, Mrs. Perry was there for a simple business conference, as we learned from Mr. Conover. Peyton Braylow works at that hotel. She's a housekeeper. She has access to master keys that will open the door to every room, including the door to room 312. Why were the police so certain they had their kidnapper in Tyler Perry? The state has repeatedly talked to you about physical evidence, but keep in mind what we know about that evidence. Mr. Nathanson told us that this chemical, chlorandramine, is the type of chemical that can transfer from surface to surface simply through physical contact. And how carefully was that evidence handled when we know from the cross-examination of Detective Walsh that at least one officer on the scene that night, Brian Budzik, was handling evidence without gloves. It's a blatant violation of police protocol, Your Honors. And Mr. Nathanson told you that that violation, the fact that Evanston detectives were violating police protocol, was repeated at each and every step of this investigation. Consider what actually happened inside the Reynolds home on the night of October 22nd. No one disputes Bailey Reynolds' story of what happened that night. We know from her testimony and the testimony of Detective Walsh that Bailey Reynolds struggled valiantly with her kidnapper. Books were knocked over, a lamp was shattered on the floor, and yet the state wants us to believe that Peyton Braylow sat downstairs and never heard a thing. We have to ask ourselves, is that a reasonable explanation for the events of October 22nd, 2004? Does the state honestly ask us to believe that Tyler Perry went into the Reynolds home hoping that Peyton Braylow was asleep, and that if she'd actually been awake when Mrs. Perry came into their home, Mrs. Perry would have politely waved and left? It's simply not a reasonable explanation for what happened, Your Honor. And yet Evanston detectives never brought Peyton Braylow down to the station for questioning. Detective Walsh sat right there in that stand and told you that he had absolutely no reason to consider Peyton Braylow as a suspect in this case, despite the fact he knew she had a criminal record, despite the fact no one could account for her whereabouts on the night of the kidnapping, and despite the fact that she had a clear connection to the Hampton Hotel. Your Honors, did Peyton Braylow have residue from the chemical chlorandramine on her hands, in her clothes, in her home? Did she have evidence linking her to this crime? Those are questions we can't answer because Evanston detectives never asked them, because they were blinded by their need to blame. In their opening statement, the state told you that some things in life are too important to be gambled with. We could not agree more. We do not convict individuals in this justice system on the basis of supposition or inference. We require evidence, and the state has simply failed to provide you with enough today. To convict Tyler Perry would be to put an innocent woman in jail while Bailey Reynolds' kidnapper goes free. And that's not justice for Bailey Reynolds and her family. It's not justice in this courtroom today. Find Tyler Perry not guilty. Thank you.
Thank you, Counsel. Any rebuttal?
Yes, Your Honor. May proceed. I would ask Your Honors not to be blinded today by the smokescreen being prevented by the defense. Peyton Braylow had no motive to demand a $250,000 ransom, and she had no animosity towards the Reynolds. There has been nothing to link Peyton Braylow to chlorandramine. And Peyton Braylow did not even have a car, Your Honors. How could she possibly have driven Bailey Reynolds 20 miles to the Hampton Hotel without one? She could not. Find Tyler Perry guilty today.
Thank you.
Thank you.
No No instructions. No,
If everyone could just remain quiet, we're going to be tabulating the ballots in the back, and the judges will take a couple of minutes each to give some feedback, and then we'll come out and make the announcement at that time.
At the outset, the thing that I would like to do is introduce to you the eminent co-judges who are sitting up here on the bench. On my right is Justice Michael Strite. It rhymes with right.
You remember.
I do. Justice Strite is a justice of the Supreme Court of Iowa. And on my left, the far left, is Odell McGee, who's an associate district judge in the county of Polk. And is that correct? Yes. And immediately next to me is Anadra Vaiteswaran. How was I?
Not too bad.
In Illinois, our appellate justices are called justices, but here they refer to judges who are in the appellate court as judge. Is that correct? So Anu, may we all call you Anu, is a judge in the Court of Appeals here in Iowa. And I'd like to first ask Mike Strite to tell us, Justice Strite, to make any comments.
Usually we start these comments out with asking each team to tell us who you are and where you're from, but they've told us not to do that this time in case there's a tie, and then we have to make a decision on breaking a tie. So we'll leave that mystery. The only one that doesn't know is us up here. We have no clue, unless you're from Britain. Okay. So
Australia.
We won't do that till the very end. This is just always a rewarding experience on my behalf and the other judges that come here to do this, because we get to see just good lawyering at its finest. And it's amazing how well done this is when you guys are not legally trained or not in law school. I mean, it's just remarkable how far you come. We didn't see any bad lawyering today. We sure did see some good lawyering. And to a certain extent, in certain ways, we see too much of good lawyering. If you were going to, if this was an intermediate round and we were suggesting some improvement techniques, I would talk to you a little bit more than I'm going to today about trying not to sound like lawyers. And you tend to do that, all of you do, because you want to sound like lawyers. And that's the biggest problem with lawyers, is they keep trying to sound like they think they should sound. If you ever see good lawyers, they're the ones that don't talk like lawyers. They're the ones that communicate. I can point to individuals on both teams that can just talk right to people, and then when they talk, they listen. A lot of that has to do with pacing, emphasis, intensity of argument, of which many of you have just mastered this technique. One problem I see on this mock trial forum is that sometimes, depending on the style of the advocate, you are intense too much all the time, and you don't stop to let people think. You don't lower your voices to let people lean in to listen and things like that. But I've seen that technique done today, where you vary your performance, you slow things down, you speed things up, you control your witness. Sometimes you have to be impervious to your witness. The last tete-a-tete with Mr. Gukin, with our liquor store owner, handled probably the toughest witness here today just very well. Just let those humorous remarks bounce off you as you proceeded through your discussion. But overall, you just, the intensity, the ability to focus your cases was just well done. And at the end result is that you convinced us up here that each of you believed in your cases. And that's the first steps to credibility and success in a courtroom, is that you convince the trier of fact that you believe personally in your case, and therefore you should win. And you do that by the way you organize your arguments and organize your pacing, your intensity, and so forth. But everything was just well done today. I have no criticisms. For the ones that come back, how many seniors we got here? Almost all of you. We have a few people who might come back another time. But the one thing, if I was coaching, which I don't do, but I've done a few times just when coaches have asked me to come for a special night to work with students on coaching, the formalism that we go through in our courtroom here is shown all the time. And in the real world, we don't quite have that formalism. I think in the mock trial competition, the judges and everybody thinks that you have to have that formalism, and maybe you do. That's like when you let the record show I'm handing the exhibit to the opposing counsel. In the appellate courts, and I've been doing this for about 10 years now, I've never seen any problem at the appellate level why the record has to show that you're handing the exhibit to the other side. I'm not sure why we care that the record shows that you are handing an exhibit to the other side. One thing that you guys did that you didn't do all the time, they always handed you a copy of the exhibit. They occasionally handed you the original, and they had to wait a minute. You guys weren't quite, I've seen this happen in the court. I was a trial judge before I was on the Supreme Court. I've seen it happen in a courtroom. You got a jury sitting there. Pacing's very important in jury trials. And the side says, let the record show I'm handing the exhibit to the other side to examine to see. And the other side said, oh, okay, it's 6 pages. I think I'll read it. And then they'll sit there forever reading the exhibit. No, you hand them a copy, and then you move right on with your witness. And they didn't do that to you here, but every now and then you handed them the original, and they said, oh, yeah, and they handed it right back to you. If you were really fighting well, you could have said, well, let me take a look. Oh, that looks okay. That page is, let me read this a little bit. And I've seen it done in the trial arena many times. But those are just some little technical things. The ceremony of court is just fascinating how we think it should be done with offering that we can approach witnesses without seeking permission. Our lead counsel over here asked that be the rule of the court. And if you do any big, long trials, you almost want to abolish that as a rule of the court because it's a real pain to make a record of every time you're going to walk up to a witness and hand him an exhibit or go to the court reporter to get one out of their pile and things like that. But since you got that motion sustained, you guys made that all very formal as we proceeded. But anyway, overall, you should all be very proud of what you've done here today and the accomplishment of reaching this final. We won't get very much chance to congratulate the winners because of the outburst that usually happens at this stage of proceedings, but congratulations to both sides. I'm just happy I got to see both of you work.
Oh, thank you. I will ditto Justice Strite's comments. I really enjoyed serving in this capacity today. Being the only district court judge, I guess, on the bench, I guess I would take a little different perspective. I really enjoyed your presentation. I thought they were all, as stated, excellent. You seem to have a great command of the facts. I am, as a district court judge, do a lot of, well, at least some trials periodically. And I was a 20-year prosecutor. And so my approach to trial work... Oh, is it on now? My approach to trial work is a little different. You argued a lot of facts. I'm still wondering if I heard a lot of law. I guess my thing about arguing criminal law is because it's elementary. I always started with the elements and said on either side and talked a lot about the elements, what the law required, and then to explain either what the case did prove or what it didn't prove. I guess I was listening for more law, and you're very emotional and all, but the law is the thing that's supposed to really win the case for you. And I did not hear, but I usually started my case as a prosecutor out by talking about what the law required, because I always thought that was what we had to do. And I guess both of you are very emotional, and that's very good, but I expected, I guess, to hear a little more law. But overall, I thought you did an excellent job, and I'm interested in the characterizations used by your witnesses. Where do you get those? I mean, CSI would not like you wearing a hat like that. They carry guns now, you know, and of course they don't in the state of Iowa, but I was interested in the characterizations and how you chose to characterize your witnesses. That was very interesting. Overall, as I must say, it was excellent, and I do thank you for inviting me to listen to you today, and I thoroughly enjoyed it.
I also really enjoyed this performance, both by lawyers and witnesses. All of you that are lawyers, I would hope to see you in court someday. It would be my pleasure, absolutely. This was a privilege. As for the witnesses, I wish I'd had some of you when I was in practice. You were all great. I really would like to thank the organizers for the opportunity to participate in this. I've been judging this competition for 15 years, and it is really a wonderful opportunity for us to see great future lawyers and future actors. And I would like to thank the organizers as well as all of you for giving me this chance. Thank you.
I think that I was a little insulted. Judge McGee, when you said you didn't hear much law, did you mean you didn't hear much good law?
No.
I mean
there's elements you talked about. In criminal law, you talk about elements. To be found guilty of this charge, the law requires A, B, C, D. They talked about the standard of proof, but not in terms of what the 3 or 4 elements are stated in the materials that I got, which they are required to do in the trial information. They usually outline what you have to prove.
No, I understand. Now, the fact is, all of you have probably noticed I injected error deliberately in my rulings. That's right, because part of the judging involves how you respond to judges making bad rulings, and you were impeccable in your response. Nobody hit the, oh my God. Because the worst thing in the world that a lawyer can do when a ruling is against them is to respond with a hit on the head.
No, the worst thing is to be argumentative.
Okay, I'll buy that too. Because then the impact of the evidence is going to be twice as hard and important, because now the jury is going to realize, well, that was something important, and that lawyer was wrong when he made the objection. But you handled it absolutely beautifully. I have a couple of things that I wrote down. For one thing, it may have been obvious to you, I don't spend a lot of time on this side of the bench. I never have, only when I come out here and judge. And for me, it's just a great pleasure. You probably could tell by the robe. Doesn't fit me. This is my robe. This is the robe of Judge Eisenhower, who is 6'3", and I'm only 6'4". I look taller because I'm slender. I'm going to make a serious comment. In the opening statement, and I'm just wondering about your response, all of you are or maybe not, but all of the mock trials I've been involved in involved jurors, at least in the final round. And I don't know whether you presume there was going to be a jury. And the little point that I had is that in the opening statement, frankly, it almost appeared artificial. You started here, you moved way beyond the line of our last judge sitting and talked for a while over there, and then you moved. It appeared artificially, the movement. When you're trying a case before a jury, of course, you're going to give attention to all of the jurors. You're going to move. It's going to be gentle. It's not going to appear artificial. Did you have that feeling?
Yeah, it's hard to fake sincerity, and that's kind of what he's saying.
Yes, it almost appeared as if I've got to be moving. I've got to show a variety of positions. Boom, boom, boom. In closing arguments, it didn't appear artificial. I thought you did a nice job moving, probably more of a gentle movement. What else do I want to mention to you? Officer, were you chewing gum?
No. It doesn't look like it.
I think I think I got the message.
Oh, we have power there in the microphone.
Now, as far as the use of exhibits, you were using the exhibits for demonstrative purposes, and it's true you can use anything of a physical nature for demonstrative purposes. It doesn't have to be drawn to scale, but it appeared to be drawn to scale on the basis of some evidence that was given. But if that exhibit is going to be used to your advantage, you've got to make sure the trier of facts really see it. I couldn't. I don't think. Were you able to see what they're showing?
Oh, I see the big blocks.
Yeah. So there isn't anything wrong with coming up closer, asking a witness to step down and use the exhibit for demonstrative purposes. Did I scare anybody by threatening to, what did I say? Get the court out of here.
Clear the court.
Clear the court. I didn't say I was going to clear the people out of the court. I was going to get the court out of here. I'm not sure of what I meant. But I felt good saying it. I've always wanted to say that. The thing that I want to do is join everybody else. You're probably bored hearing about how good you were. You were all truly superb. And if you want to become lawyers, there isn't any question about it. You're all going to be fine, fine lawyers, and you may even go beyond that and become great actors. You were all wonderful actors. I want to thank everybody connected with this, and especially especially Dick Hawkins, who is the founder of this program. He is the genius, and it was an honor working with these guys up here. Thank you.
All of the attorneys and the witnesses who are on the rosters of these two teams are All-American attorneys and witnesses by nature of making the final round. These two teams are the best out of almost 600 that started the season. That makes them the top 1/3 of 1% in the country. I'm going to ask one captain from the state to stand and introduce the program that they're from, as well as his teammates, or her teammates, and then the judge will finally find out who they've been spending the afternoon with, and after the state goes, we'll proceed to the facts. We're representing Harvard University in Cambridge. Could you just please introduce your teammates so everyone knows who you are? Absolutely. This is my co-captain, Daniel Goodkin. This is Talia Kramer, Todd Van Stoke Riley, Carolina Lascano, Matt Roller, Mia Morgenstern, and Joseph Kearns. Where are they? Thank you.
I represent the University of Virginia from Charlottesville, Virginia, along with my co-counsel Daniel Young, Jamar Walker, also with Ryan Burke, Mustafa Abdel Karim, Benjamin Sachs, Sean Hamidi. We're traveling today with Ashton Alexander, right there, and Kevin Richards, and our coach Ryan Faulkner, and Stephen Conjo. Where's he?
Both teams performed outstanding. What you've all just witnessed is the closest national championship round in AMTA history. We had 3 judges. We had 1 ballot for the state, 1 for the defense, and 1 tie. By rule, we go to point differential, with a point differential of 1. Wow. Your national champion is the University of Virginia.